15. Yes. Infractures. Okay, just a minute. Mr. R.J. Das, Learned Counsel for the petitioner, submits that the matter has become infructuous, and accordingly, the matter may be closed as infructuous. Mr. Ms. A. Verma appears on behalf of the NRL. Respondent number? Appears on behalf of respondent number 3. Anyone else? You're here? No. On the prayer made by Mr. R.J. Das, the writ petition is closed as infructuous.
Well, item number 22.
22,
This
yes.
person, Kamala,
Huh?
sixth time we get to file. I file affidavit. I've taken consent.
Who's for the other side?
I've taken consent. I am Vishwas Miller.
Okay. Mr. S.K. Medi, SC Railway submits that. Is granted
Three weeks time.
3 weeks time to file affidavit in opposition. Miss
AK Chopi.
A.K.
Chopi.
How do you spell that?
AK CHOPH.
C.H.O.P.H.I.
HI.
Huh? Appears on behalf of
And Biswas.
M. Biswas, Learned Counsel for the petitioner.
But 29th of May, my lord.
This is the matter after 3 weeks. Huh?
29th of May.
This is the matter on 29 April.
May.
29 May.
File. Item number 30.
13. 1 3. Yes.
4 weeks time to
Reply. Affidavit in opposition has been filed. If affidavit in opposition is not filed, where's the question of filing reply? Huh? You're for the respondent. Okay. So you need to file affidavit in opposition, not reply. What is your name? Mr. K.M. Kakoti appearing on behalf of? Huh? 80. No. Who is the? Are you the counsel for the ATPFO or are you the senior appearing? Who is the senior? Got the Vakalatnama, not you, na? Then appearing on behalf of what is your senior name? Jay Bora, counsel for the ATPFO. Is granted 4 weeks time to file affidavit in opposition. Oh no, wait a minute. This is a 2019 matter.
Yep.
Why? 5 years have gone by. When engaged when? '23. Which month? Mr. Counsel, 23. Now it's 24. 24 May. Already 4 months have gone this year alone. He's granted 2 weeks time to file affidavit in opposition. List the matter on give a date.
Item number 8 and 9. 8 and 9, my lord.
8 and 9.
2016-17 methods. But I would like to have instruction from a client whether anything, my lord, exists in this case. Can it be on Friday or Monday, my lord? It's regarding the allotment of soaps to the, my lord, fish market, in a fish market, my lord.
Where is the petitioner?
I'm for the petitioner, my lord.
Ah, yes. Okay.
There is an association. I've informed them today. They will have it.
No, you see, this 8 is infructuous. 8 is gone.
Same issue, my lord.
8 is gone because 8. Now the prayer that you have made in 8 now has been taken over by 9. In 8, what has happened is the two representations your representations were to be decided by the authorities. Now that representation has been rejected, and that you have put to challenge in the subsequent writ petition. So the earlier one goes. There's nothing. Same prayer.
Let it be on Friday, my lord. I will mention in the 10.
Okay, right.
On Friday.
Mr. B. Goel, counsel for the petitioner. explains for time to obtain instructions as to whether the two repetitions have
Yes.
become infructuous.
Yes.
First up. That's right. The WPC 3233/2016 is with regard to the petitioner's prayer for allotment of space in the new market building.
Yes.
First up. While order dated 27/5/2016, this court were to apply for space in the new building before the authorities. First up. The application for the petitioner, the application made by the petitioners having been rejected, the same was put to challenge in the subsequent WPC 2432/2017. List the matter on Friday,
Lordship,
on which date?
said I am paying for respond number 2 and 3 municipal board. I have also taken instruction, Lordship. So let the matter come up on 8th, Lordship.
No, let him take it. List the matter on Friday, 3rd May, on which date?
Yes.
The Mr. B. Gogoi shall obtain instruction as to whether the matter has become infructuous. Full stop. Miss
P. Bhattacharya.
P. Bhattacharya,
Two and three.
appearing for the response number. Who is
Two
2 and 3? Who is 2 and 3?
Municipal board, Lordship.
Guwahati Municipal Board.
No, Mongolai municipal board.
Appearing for the Mongoloi Municipal Board shall also obtain instructions as to whether the old building, the old market building is still standing.
No.
Demolish.
New market, whether allotment has been made.
No, miss, you see, one thing is this. Your case was that
They are constructing.
they are constructing a new one, you should be there.
Yes.
But the fact was that the old market, you were still occupying the old market building. Now the question arises, if the old market building is still standing and you're still occupying it, and there's no question of demolition, then where is the right for a new market
The
building?
new one has been constructed. On
So
Friday,
what?
we'll clarify. that.
You are still in the old one. So what have I said? It's still standing.
Lot.
No, the old market building, in which the petitioners have been allotted space is still standing.
Also, as for the petitioner in item number 27, well, as per order dated 24 April, my lords, we have been asked to take fresh steps upon respondent number 7, who's a private respondent, my lord. So we'll do that accordingly.
When?
Well, we'll do it today from the High Court, and we have been also asked to serve through the Dibrugarh Civil Division.
Okay, Mr.
M. Burman, my lord.
M. Barman submits that he will take steps today to comply with the Lavazima court order for taking fresh steps against the respondent number 7. List the matter after 3 weeks.
Matter will be listed ordered on 8th of May, madam. Matter released the non-payment of due amount in respect to training, madam. The trainings under the petitioner is the authority of the training center and the amount that have been paid. madam.
Okay. Yes,
Maybe, your lordship, paying for listing of a matter, your lordship, the matter pertains to lordship. An elephant from Assam, lordship, has been kept captive in Tamil Nadu for long, your lordship. Lordship, it's an.
Old matter.
It's a repetition by the state of Assam, your lordship.
is it for this court?
Lordship, it's a bench 4 matter, your lordship. Bench 415. Five from Mati. I'll approach a bit more.
It's an old matter, I think, that elephant matter.
Because that is number 39. There is a possibility of settlement within the party. But the matter has been placed before the local.
Huh? That's the only hope. No NIT, but material supplied. No work order, no supply order, no NIT, but material supplied. And you want money for supply of material. I don't know who's for the other side. Huh? We cannot send it to the Lok Adalat only on you see, there has to be an attempt to settle. If the other side says nothing doing, then there's no case. You call the other side. We'll see. Huh?
Non-payment of supplier fee.
When did you file the case?
Yes, okay. 01/12/2023. That's 15. And that I was filing 22/11/2023.
Last posted in 23.
Yes, sir.
Last listed, okay. Okay. When? When? You want it on 13/5? Okay.
I think one for what you're. My lords. The petitioner's application was placed, some deficits were observed. And then, my lord, he was asked to clarify. Now he has given some supplies of documents, it will be considered.
When?
When the next meeting sits, my lord,
When will the next meeting sit?
that is up to the CCF, my lord, it will be taken care of. My lord. This
No, who is looking after that,
circle
pollution
level
control?
committee, my
Huh?
lord, circle level permit committee. Which is, my lords,
No, circle level permit committee is only to, send the documents to the pollution control board.
no, that is the confusion, my lord. What will
Okay.
happen, my lord? We don't send anything. The petitioner has to supply documents as regarding pollution, any other thing. That is not our concern. He will supply all documents, we will consider his permit.
The circle level committee.
Yes, my lord.
Okay, so
Headed
you-
by the conservator.
So we'll direct that you decide within a specified time period.
Yes.
End of the matter. Why keep it pending?
Yes.
Okay, right. Heard Mr. R. Mazumdar, learned counsel for the petitioner. And Mr. D. Gogoi, learned counsel for the respondent numbers.
My lord, I am for 1, 2, 3, 4, 5, till 6, my lord.
1 to 6.
Yes, my lord.
While Mr.
As Burma for 7 and 8.
S. Barwa appears for respondents number 7 and 8. So 7 and 8 has got nothing to do.
In fact, from my official information, what I have gathered is that for 2024-25, they have applied for consent to operate, but that is under consideration because of the lack of some documents as he has already found.
No, but who is to decide? He's
No.
saying that he has to decide. You are saying you have to decide. Who has
No.
to decide?
My lords, the pollution papers has to be furnished by them. So they'll give him the requisite pollution permission. After that, he will come to.
So has the requisite permission been given to him?
Not-
Why? When is it going to be decided?
So, that details I don't have, but already he is an existing unit, but previously consent to operate was given, but time to time it has to be renewed.
No, that is all right. That is all right. That so we know. The thing is that all the documents has been submitted by him or not?
No,
Huh? No? Which documents have not been submitted?
this inspection report has been sent across to me. From here, we can find out that the document can go into the last portion. As far as the conduct incompetence of relevant sample information.
Your lordship, you kindly speak, page 41 of my report.
Ultimately, certain level of
Certain 4 conditions were there,
pollution is
your lordship. Page 41.
Yes, which one?
Here, water spraying system,
Yes,
boundary water,
yes.
tree plantation, wind breaking wall. All these have been complied, even in this eastern division, I have any.
Maybe if I have to be considered, the relevant concept pollution makes them.
I have annexed even the photographs. Your lordship, annexer 18, page 77 to 79.
Just tell me something. The pollution control board has to give you what? What permission?
So,
Has to give approval for what?
granted by the forest department.
Arey, no, pollution.
What is the role of the pollution control board?
41.
Pollution has to give consent to operate.
Consent.
Yes,
Consent to
yes,
operate.
that will be forwarded to us, my lord.
Consent to operate.
Yes, ma'am.
And then you have to give
Yes,
the,
ma'am, that's
consider the
Yes,
extension of the
yes,
license.
ma'am, that's all. Ma'am.
At the time,
Yes, when are you going to do it? So where is your application to them? Mr. Petitioner, where is your application to the pollution control board?
No.
Page 18,
Be confused for you.
copy to
This is for installation of stone crusher unit. Mr. Council,
it for, already,
Forest
it is to provide, you see, to provide you permission to start the, now you have already been allowed to start. Now, where is your application?
the language is wrong. It is for renewal.
Mr. Council, if you say you are going to Jawai or you're going to Shillong and instead you go to Calcutta, then what are you going to say?
Your permission is already there.
That we have to expect, you are deemed to have traveled to, deemed to have been traveled to Shillong or what? You see, we go by what you say. You cannot say that when I say I'm going to Kerala, it means I'm going to America. It is not like that.
Page 35 is the content to establish by the pollution control. Page 35.
Mr. Council, have you understood the question? Where is your application
For renewal.
for, yes, yes, where is that?
Renewal. As per the permit you are obtained,
I'm dismissing your repetition. You file a fresh application. You show me.
understood your obtained. Okay, whatever the requirements I will show you.
Mr. Council, first of all, where is your application to them?
Sorry, I have instructions that all the requirement is fine. The next year I will find an additional. For renewal, all the requirement is fine.
You see, this court again was pleased to dispose of. Where is this writ petition? 6307. Where is this order?
Page 34.
74. This is of 19/10/23.
Delivery is page 70.
It is observed that the pendency of the writ petition shall not be a bar for the respondent authorities to consider the matter of renewal of the petition, permit of the petitioner in accordance with law. Then what happened? Then 1910. Then 552.
For your mercy order, I have submitted online application to 2023. With all CPD keys and documents.
Okay, submitted online. Yes. You have got his application?
Yes, that we have got. I have already admitted because my instruction says that application is being under consideration. So
you consider
after
it.
incorporating certain terms and conditions, that application will be considered consent to.
When will you
So
consider?
that time limit I can't. submit.
Then I'll
So
give
for
you
that
time
matter-
limit. I'll give you the time limit.
Yes, ma'am.
Right. What have I said? Heard Mr. Spencer and Mr. Spencer, na? Full stop. The petitioner's grievance is that despite the order dated 19/10/23, passed in WPC 6307 of 2023, and the order dated 5/2/2024, passed in WPC 6307, no, wait. No, just say, don't say, just say in that despite the order dated 5/2/24, passed in WPC 6307 2023. The petitioner's application for a renewal of his license to operate his stone crusher unit has not been decided by the Pollution Control Board, and the circle level permit committee. First up. Mr. Mr. S. Barwa appearing for the Pollution Control Board submits that though the petitioner's application has been received, comma, the decision has not been taken for giving consent, giving renewal to the consent to operate
For the year 2024.
the stone crusher unit for the year 2024-25 till date. Full stop. Mr. D. Gogoi submits that the circle level permit committee will consider the petitioner's renewal of his license for running the stone crusher unit only after approval is given by the pollution control board. Full stop. Next, in view of the stand taken by the counsel for the respondent, and as the petitioner's applications have been received by the pollution control board, comma, the pollution control board shall take a decision with regard to the renewal to consent to operate. Not consent to operate is but commas, huh? The stone crusher unit within a period of within a period of 3 weeks from the date of receipt. Huh? No, the period of 3 weeks.
1 month because
Why?
majority of the officials now are on election duty. So
Election will finish on 7th.
that will
After that,
finish,
they
but
will,
ultimately they will have some.
nothing to do, nothing to do. You just have to put in the strong room. You cannot put it in a house of the office. You have to put in the strong room. It'll be there on the 8th. Within a period of 3 weeks from the date of receipt of a certified copy of this order. Full stop. The circle level permit committee shall thereafter take a decision on the petitioner's representation within a further period of 3 weeks from the date of receipt of the approval from the pollution control board. The writ petition is accordingly disposed of. As name, disposed of. Yes, madam. No, what is your name? S. Baishya, appearing on behalf of Miss S. Baishya. So covered matter,
Covered matter, package will be different, package will be, I think, 34.
34.
30.
And again, same thing.
Same thing. I'm appearing for all the.
Huh?
All the.
Disposed of. It's here. Huh? Covered matter.
33.
Yes, madam, what to do?
Lordship, in this case, the DC officer will make the payment. The district commissioner of the concerned.
So we have to issue notice,
Yes, Lordship. Party order.
madam. That's all, issue notice. Third, Miss
Point number 4.
P.
This point number 4.
Huh?
3.
P. Shitya. Learned counsel for the petitioner who submits that the contractual dues amounting to rupees 92,500 has not been paid by the respondents. Which page is it? Is it admitted amount? There is a balance, out here it's 95,200. Yes. You are appealing for whom?
But I am appealing for deputy constable, our name is not been shown, madam. I have
No, that is a different issue.
Yes.
Look at this page 16 and 17.
16, madam. I have to take instruction.
Okay. She submits that the RTI reply dated 8/2/2024 issued by the SPIO cum Assistant Engineer, Barpeta WR Division has clearly admitted to the fact that the amount of rupees 95,200 is payable to the petitioner. Issue notice returnable in 4 weeks. Ms. S. Loda,
A loader.
A Loda appearing for
Respond 1 to 3.
respondents number 1 to 3 submits that the payment of any admitted amount is to be done by the district commissioner. Bracket respondent number 4. Full stop. Mr. M. Chetia accepts notice on behalf of respondent number 4 and submits that he will take up, he will obtain instructions in the matter. What about you? Are you need to take nothing?
Lordship, they have to make the payment to us, then only we can transfer the same.
You file affidavit with regard to the admission. Okay, the counsel for the respondents shall file their affidavit, shall obtain instructions and file their affidavit by the next date.
This
is a matter of the 4 weeks.
In the respondent,
Huh?
our name may be shown.
Registry to reflect the name of
Government.
GA,
Yeah.
GSM in the cause list.
Oblige your lordship.
Huh? Huh. Okay.
I'm in item number 15, Lordship, I'm appealing.
Yes. He'll tell it. Miss, what is your name?
D. Borpujari.
D. Borpujari appears for respondent number
4.
4 in that item number 15, huh?
Okay.
Issue notice?
Lordship,
Correct. Heard Mr. KP Pathak, learned counsel for the petitioner who submits that the petitioner has not been paid his supply bills amounting to rupees 43,12,500 for supply of, what is this? Rabi, RABI hybrid vegetable seeds. Correct. Issue notice returnable in 4 weeks. Miss
Z Bora for 1 and 2, Lordship.
G.
Z, Lordship.
Z means G or Z?
Z for Guwahati.
Oh, G for Guwahati. Okay. G Bora accepts notice on behalf of respondent number
1 and 2, Lordship.
1 and 2. Anybody else? What about finance department? While Miss
RM Bora, your lordship.
RM Barua accepts notice on behalf of respondent number 4. Petitioner to take steps for service of notice upon the respondent number 3 by registered post with AD within 2 days. This is the matter after 4 weeks. And in item 5, I think same, except the amount will be 40,29,579.45.
The product is certified groundnut seeds.
And out here certified
Certified
groundnut seeds.
Hello.
This petition has been filed. But the petitioners for a simple, which is simple disposal of the representative submitted by the petitioner. Then 585% lordship. They are ration card holders belonging to a PPL category.
They are ration card holders,
Ration card.
but only 12 of them have come.
Yes, the PL. Lordship,
Then-
we are among the PL lordship,
This is not a PIL.
not a PL.
Then I cannot.
Even if my lordship, even if my petition is concerned, lordship, they will all benefit. I'm just trying to highlight the magnitude of the situation. You guys all are simple. My fair price shop has been changed to another area, which is beyond the area permitted by the rules.
How far is it away?
6
10 kilometers.
6 kilometers.
6 kilometers.
What is happening is, as per I'm annexing the government rule, that says it should be within a radius of 3 kilometers.
Which rule?
Please, there, so page number. I'm giving a page number. Later the page number 92, lordship. This there are alternatives available, lordship, nearby pairs are not just one. 92. Let them take me to us why 6 kilometers, drag us to 6 kilometers.
92 is only
93, lordship. 93.
Okay.
Never, it needs to be
So
ensured that no country-
you let him, do you decide his representation?
Yes, yes, yes.
If
What?
your lordship wants to dispose of that.
Naturally, otherwise what is going to be done? If waiting for your reply will take ages.
In the meantime, they'll be starving lordship.
Waiting
Yeah,
for your
conflict
reply,
days.
you will not starve, only thing you'll be more tired, that's all.
Otherwise, I want to highlight one point, my lord.
Yes, yes.
The suspension order has been challenged by the agent, my lord,
That's
which
a
is
different thing.
pending.
We are not,
Okay, okay,
we are
that's
not-
fair
That
price shop.
Yes.
we are not country of this lordship. We
Huh?
just want any shop. Not,
Okay, any shop.
not, we are.
Okay, any shop that is within,
Then-
closer to them, that's all.
Lordship, there are other places nearby lordship.
That fair price shop that is under suspension, that we will not touch, that we will not touch.
Residents of part one, the, new shop has
If-
given a part three.
If there are other fair price shops there.
Yes, no, in between
Nearby,
there's part
within
two.
3 kilometers. If there-
Part, within three, and even part
If
two.
if
Part
there
one
are,
and
if
part-
there isn't, then that's a different thing, but this cannot be this cannot be a ground, I hope it's not an indirect attack
No.
on the
We
government
are saying any.
by
any
the,
shop.
by the fair price shop
Not,
owner.
not that we are not trying to defend that particular shop, it's any shop. In fact, there is one in between one and three, part one, part three area. That will also be it. Why part three, they got 6 kilometers of it.
Okay, right, Mr. R. Goswami, Learned Counsel for the 12 petitioners, is it 12?
Yes, 12.
12 petitioners submits that the petitioners and another 500 or more ration card holders had been taking their PDS or
PTS commodities, lordship.
PDS commodities from
It's represent, page number 16, lordship. From a shop in part one area. Namely Rakesh Singh.
page 60 from
Annexure
a
of
fair
page
price shop
16 in part one area.
being run by the fair price shop in part one area. Part one area of what?
Part one.
Huh?
Part,
Part one.
Labakpur part one, Labakpur. Labak part one.
Where is that?
That I have given in my petition, say this. Labak part one.
It's not in the representation.
It's not
It's,
written.
it's in the, not in the, but in my petition is there.
Where?
I'm just specifying. But
Where?
even this will do, lordship.
Where in the writ petition?
Petition page number, lordship, 6 is there. Labakpur part one. Labakpur part one, lordship. Paragraph 2, lordship.
Paila pool.
Yes, lordship, Labakpur. There's part two in between, but they shifted us to part three. That is a problem, lordship. They can give anyone in part two also.
Just a minute. What have I said? Had been.
My lord, may I point out one thing?
Yes, yes. Just a
My
minute.
lord, my lord,
Huh?
kindly see the representation of third paragraph. my lord.
That paragraph, yes.
It is therefore felt that you would be kind enough to return back to our original fair price shop of Rakesh Singh.
Ah, yes.
Lordship, now we have changed that stand in our next lordship. There are reminder also was there. If they don't agree, let them give it to anyone. There's a reminder. Then page 63, lordship. Till that no action is taken, so we any alternative, any chop, lordship. Now we are saying that any shop, give us to tag us to any shop. We don't want to get into this problem between Rakesh Singh and the government. We are our praise for any shop. Maybe representation in your.
Here is the same condition.
Where is the prayer? In
Same.
your affidavit, nothing is there. In your representation, nothing to that
63
effect.
also, my lord,
Not
kindly
the
see.
president, but in
You
the.
make- you
representation,
make-
dear Lord. Lordship, we kept the, lordship, just, I just-
Mr.
I just
Counsel,
want
no,
one-
no.
one point.
I'm dismissing your repetition.
Lord,
Either you withdraw, file a fresh representation there, When they have said that fair price shop has been suspended, you have got no right. You are a third party.
No, but Lordship, we are not praying for any shop, Lordship.
Where is your prayer?
Yes, not in this petition, but in this petition, we are praying for any shop.
Where?
I'll just sit out.
Huh?
Lordship, give me time, I'll just sit out. Prayer for any, tagging to any shop, Lordship.
No, you make a representation for any other shop.
Lordship, just one, we have made a prayer. Page 13, Lordship, prayer, we have made a prayer, Lordship. Para 9, Lordship. Para 9, Lordship. Yes, we have made a very prayer. We waited for that, no result was coming. That was about 3 months back. Now we are, Lordship, what has happened? I'll just embroil. The fair press have also surrendered, Lordship, the new one. He said, I cannot get out to these people. Because he already has his own workload. I have annexed that, Lordship, page 94, Lordship. Even he has surrendered now. Now where do we go, Lordship? So we are praying for tag us to any shop. Page 94, Lordship. These fellows
Mr. Counsel, please read para 9 of your article.
Yes, sir.
It says here, the last sentence.
Yes, sir.
Please read the last sentence.
The alternative FPS is within 3 kilometers. Residents of all the ration card holder who were tagged to FPS of Alok Das.
Who are tagged with Alok Das.
Alok Das. Now he
That
said,
doesn't
who have
matter.
now relinquished the duty I imposed on him. Even he said, I cannot do it. That's his page now 94.
No, you are changing your
No,
stand
no.
as you go along.
No, Lordship, just 1 minute, Lordship. Page
Okay, I'm
number
dismissing.
94, Lordship.
I'm dismissing.
Lordship,
You
page
withdraw.
number 94. Page number 94, Lordship, may see. Even this person has surrendered. He said, I cannot do this.
Mr. Counsel, you are writing something here different and you are asking for different
Lordship, these
prayer.
representations have been pending for more than 6 months now.
Mr. Counsel, when you ask for going back to a shop which is under suspend, which is
No, not to him,
suspended,
not to him, Lordship. Lordship,
you make that prayer.
No, it's there. Lordship, para 9, I'll read out para 9.
No.
Lordship, just give me
Dismiss.
one. Take time, Lordship.
Next. Otherwise, you withdraw and file a fresh representation, that will allow. That's a different. You withdraw this representation.
Lordship,
No case that way. Mr. Counsel, please understand. You withdraw, you file a fresh representation. If it is not considered, then you come, we'll pass an order.
Yes.
But not on a representation on which you have asked to go back to a suspended shop. Mr. Counsel for the, Mr. R. Goswami, counsel for the petitioner, says that he may be allowed to withdraw the writ petition with liberty to file a fresh, praise allowed. Writ petition is dismissed as withdrawn, with liberty as paid for. Mr.
G. Bukul.
G. Bokaliel appears for the,
All that.
all the respondents.
All right.
Put in them.
Your Lordship. My lord, this is for my lord, disconnection of my electricity method by private respondent number 6, my lord. I have applied for the authority, my lord. Lordship, may kindly see page 61, my lord, my application. And in the right side of the application, my lord, there is the endorsement, my lord.
Mr. Counsel, is there any suit between your
Oh, yes, that was pending, my lord.
title suit? What is the number of title suit?
My lord, this title suit number is, my lord, 98 of 2020.
Who has filed this?
This petitioner, my lord.
Petitioner.
Yes, my lord.
Then
Regarding my lord,
with regard to disconnection of the electricity, did you go to the?
No, my lord, that was my lord filed for confirmation of position, my lord.
Huh?
Confirmation of position.
Confirmation of possession, what is the number?
My lord, 98. Please, my title suit number 98 of 2024. I have
This is
annexed
for what? Confirmation of?
confirmation of possession. Basically, my lord, confirmation of possession, my lord. Because
Confirmation of possession of what? Of the property?
property, yes, my lord.
So that means you're not in possession or? There is
No,
a
my lord,
dispute with regard to possession.
No, I am in possession, my lord. And
Who is the title holder of the land?
my lord, I am the title holder. My
Where
father.
is your title? Where is your land document?
Our land document I have annexed, my lordship will find. In title suit, lordship will find it. Lordship, may kindly see the title suit.
When there is
My lord,
when
page
there is a
30.
suit for
Page-
confirmation of confirmation of possession, not title,
Lordship.
confirmation of
Title and
possession.
possession, my lord.
So it appears that there is a dispute with regard to who is in possession of the land. Won't it be?
No, my lord.
Or what?
He has filed a miscase also
Huh.
for in that same suit, where one of the prayers is that to pass a necessary direction for restoration of electricity connection.
I was waiting for him to turn to page 60. I think I replied on page
My
60.
lord, I will answer lordship. Lordship may kindly see page 30, my lord.
Huh?
Page 30,
30.
land document, my lord.
No, okay, page 30, yeah.
It's the land document, my lord. It's the name.
In vernacular, I can't read. I don't know.
Lordship. And my lord, may kindly see.
I don't know. This is, aren't you supposed to translate all the
No, my
documents?
lord, Supreme Court, my lord, already said that, my lord, when the possession is not disturbed, my lord.
Mr. Counsel, leaving that aside, there's a question I've asked you. The question is, isn't it your duty to translate page 30?
My lord, this is my lord, inadvertent, my lord. because-
Inadvertent error.
Yes, my lord.
And you are saying that I do not know, I can't read who is the owner of it.
My lord, lordship may kindly see. the-
Anyway, now you come to page 60.
Yes,
Come to page 60.
60, lordship,
Cut a long story short.
lordship.
Please read the order.
My lord. Page 60, my lord.
Yes, yes.
This case, J case has been registered on the stand of the petition number 920/2024 filed by the petitioner plaintiff under section 151 CPC for restoration of electricity, water supply and other indemnity. Heard the learned counsel for the petitioner issue notice to the opposite party. My lord,
Who has filed this petition?
my lord, this plaintiff has filed, but the,
Plaintiff means you.
yes, my lord,
You have filed this petition for electricity
yes, my lord.
on the same issue.
Against the respondent number 6,
Which you have filed here.
yes.
Can you go, can you have two parallel proceedings? This is
No.
in a civil suit.
I have cleared, my lord, because, my lord, this FPTCL not a party in that suit, man. So I can't, my lord, may kindly see the relief which I sought in the 151 petition, my lord. I have annexed this also, my lord. I have made everything clear, my lord. Lordship may kindly see.
Where is your petition? Where is this miscase? Where is
Lordship,
this miscase 92920
Yes,
of
yes, I have
2024?
annexed, my lord, this one, my lord. Lordship may kindly see page 31, my lord. Page 31 is the miscase, one miscase, my lord.
This is at page 49.
And for page 49 will be, my lord, another miscase, my lord, which was filed at 151, my lord. Page 49. Lordship may kindly go, prayer question, my lord.
I want miscase number 179. Where is 179?
Page 49,
Page 49.
yes, ma'am.
This is not 140, this is 179.
179.
Okay, 179. Yes.
Yes, madam, miscase number 179 and petition file under Lakshmi kindly see the prayer question, my lord.
Yes.
So, my lord, regarding possession, my lord, can you kindly see page 37, my lord. Respondent number 6 issued notice. He is saying that we are the tenant, my lord. So either my lord tenant or my lord owner, we are in occupation, my lord.
No, but then you have already filed an application before the civil court.
My lord, that was against the respondent number 6, my lord.
Correct.
But now my grievance is against the respondent number, my lord, other private official respondent. I have filed application, my lord. And that application was, my lord, withheld only because he has filed objection, my lord.
Why didn't you plead? So he has filed objection in that, in 179.
Yes, my lord.
And
No, my lord, in this petition, my lord, lordship may kindly page 61, my lord.
but
Right
the
side-
same issue is there. Why don't you plead this party there? Because this,
Well,
the entire matter is there.
My lord, it will go, because they are the government, we have to issue ITCPC.
No, not required. No.
My lord,
Sorry,
this-
sorry, ATCPC
My lord,
not required, not in this.
In this regard, lordship, even.
This is not going to be a suit.
Lordship may kindly see this to order. One is.
No, I've got Supreme Court orders.
And this court also, my lord.
What do you
direct,
say?
my lord.
Law, I have no dispute. That law is settled.
Law is settled.
The issue is that there is a pending application.
That is what is the pending application before the civil.
My lord, in
Now, I don't
pending
know.
application, I have stated that in the meantime, I will, my lord, apply for the new connection. But new connection is, my lord, the.
Only
rejected.
temporary connection can be given to you. No
That-
new
that-
connection.
That will do, my lord.
No, but I do not know, but the issue is this. When you have gone to the civil court,
My lord, against the private respondent number 6, there is dispute going on, my lord. He has disconnected.
Perhaps what can be done, since this issue has been going on for some time, let him take dusty on the private
yes,
respondent.
that is, I think, better.
Then
Then we'll decide.
My lord, this honorable court also passed.
Right.
My lord, kindly
Right,
have a look, my
Mr.
lord.
Giudice, learned counsel for the petitioner, who submits that there is a title suit pending between the petitioner and the respondent number 6, filed by the petitioner, seeking a declaration of possessory rights over the suit land. The petitioner's case is that the respondent number 6 has illegally cut off the electricity.
Yes.
He submits that, the cut off the electricity for which Miss bracket F, is it F or what is it?
My lord, J, my lord.
J, Miss bracket J. Case number 179 of 2024 has been filed in title suit number 98 of 2024.
Lordship.
Pray for restoration of electricity, water supply and other amenities. Full stop. The next date of a Miss J case number 179/2024 is 15/6/2024.
My lord, 15/5 will be actually.
15/5/2024. And now it's one, so it's just a few days away.
My lord, may I, my lord, kindly, my lord, have a look, my lord. This honorable-
15/5/2024, full stop.
My lord.
Hmm.
My lord, petitioners are, my lord, in a pathetic condition because they moved, my lord, before the civil court, my lord, then authority, my lord, then this honorable court, my lord, in the Guwahati city, my lord. They are without, my lord, current, my lord. Since 10/4, my lord. And thereafter on 20, my lord.
Mr. Counsel, this application of yours was submitted when?
My lord, I have submitted on 22,
When? Which month?
2024, my lord. And they rejected it on the same day, my lord.
Who rejected it?
This FDCL, my lord. Because, my lord, they have stated that in the right side corner of that, my lord, let's me kindly see. The objection is to issuance of electricity received from Ram Iqbal Das, that is respondent.
Anyway,
number
what
six.
have I said? The problem is, you see, the law is not an issue. The problem is that you are going to
No, my
two
lord,
parallel proceedings.
my lord,
that is the
I can
issue.
seek relief, my lord, from them, my lord, from this honorable court, my lord.
You take justice service on them, we'll list it next week. We'll dispose of
My
it.
lord. My lord,
Or
this
you
honor-
can get it if you can, we'll list it on Friday.
my lord, I have.
You can do it, by Friday, you give them notice, then we'll dispose it of.
My lord,
The only issue is with regard to possession, that's all.
my lord, that's why, my lord, it's a.
Mr. Counsel, let us
respondent
hear the
number
other
six
side.
says, my lord,
What have I
confirm the
said?
position, my lord.
Full stop. Next paragraph. On a query to the learned counsel for the petitioner as to why the petitioner had approached two parallel proceedings, had initiated two parallel proceedings for restoration of electricity, the petitioner's counsel submits that the APDCL who is to restore electricity is not a party in Miss J case number 179
also.
2024 or in the title suit number 98 of 2024. The issue notice returnable in 2 days.
Lordship.
In 2 days. Petitioner is granted. Petitioner shall serve notice upon the respondent number
Six, my lord.
by through dusty service
Right.
and file affidavit of service by tomorrow.
Right.
This is the matter of Friday. Okay, before that, right, Mr. K.B. Patak, accept notice on behalf of the
APDCL, respond numbers 1, 3, 4, and 5.
1, 3, 4, and 5. Who is 2?
Who is the
Ganesh
government?
Secretary. Mr. Bokalial, accept notice on behalf of respond number 2. G. Bokalial. You come by tomorrow, you file, you get the affidavit, then we'll see.
Only, my lord,
2 days you suffer, that's all.
I am in pathetic condition, my lord. One lady is in advanced stage, my lord.
Advanced stage of what?
Pregnancy, man. I have arranged the document, man. And this honorable court also passed, my
You
lord.
come day after tomorrow. You come. You have avail of two parallel proceedings. I have to give notice.
I have cleared in my petition, man.
Ah,
I have cleared in my petition, man.
Mr. Counsel. Okay, next.
Obliged.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. T. Deori, Your Lordship, interlocutory application for impletement of party of the respondent number 5, Your Lordship.
Right. Heard, Mr.
D.S. Decca, Your Lordship.
D.S. Decca appearing on behalf of
Mr. T. Deori.
T. Deori Land Counsel for the applicant who submits that the Union of India represented by the Commissioner, Ministry of Jal Shakti, Department of Water Resources, Rural Development and Ganga Rejuvenation should be pleaded as respondent number 5. Miss A. Loda appearing for the
1 to 4.
for appearing for the respondents submits that she has got no objection to the application being allowed. Accordingly, the Union of India says so. It is pleaded as respondent number 5. Applicant to submit a corrected copy of the cost title to the registry. I is accordingly disposed of. Then in the main case, in view of the order dated 1/5/2024, passed in IAC 1157 of 2024, Union of India Spencer, the imperial respondent number 5. Issue notice to the respondent number 5. Who is the CGC? Miss A. Gayan. Miss A. Gayan accepts notice on behalf of the newly implemented respondent number 5. Petitioner to serve a copy of the writ petition to the learned CGC during the course of the day. This is the matter. When?
After 4 weeks, Your
Why? Why 4 weeks?
Lordship.
Just show me the writ petition. You asked Miss Loda why she is smiling. You asked her. Okay, since you have paid for it, this is the matter after 4 weeks. Then you can ask her outside the court why she was smiling.
Lordship, item number 7 is also the same.
Okay, item 7, same. I respond number 5, huh? Same.
Much obliged.
Then out here, only thing is that the IA number will be
724.
1158 2024. 1158.
Much obliged, Your Lordship.
Now you outside you ask her.
Yes.
Same order which I was planning to pass maybe tomorrow or the after.
Made illegal.
We wait for the affidavit.
In first case, they have not filed.
Yes, who is appearing?
Devi Pathak is appearing for this case.
Who?
Devi Pathak.
Yes, what is to be done here?
They have challenged the assessment, final assessment under 126(3). Otherwise, the law is settled that they'll have to avail the remedy under 127. Now, after that, if they have any grievance, then they can.
Still, Lordship may kindly tell the final assessment order. Not non-speaking order, total non-speaking order. Your Lordship,
The division bench has held that even issues of due process, if they have to be raised, that can be raised under in the proceeding under 127.
may I place my case. You know what happened in this case, my lord? An inspection was conducted in the premises of the petitioner. And it was alleged that the petitioner's connected load was 104 kilo. Oh, 840 kilo,
How much? 848.
40 kilo,
848.
40,
40.
840
840 kilowatt.
kilowatt.
Huh.
As against the authorized connected load of 418 kilo.
How much? 418.
18. Now, my lord, as per the applicable provision, if the metered connected load is found excess, then the petitioner will be liable for penalty. What they have done, they have simply counted the ratings of various machines and motors available in the premises, which were authorized by them to run through changeover switch as well as my own generator sets. They have taken into consideration all these. Had there been, they switch on the entire machine, they could have found what is the meter load used by the, because under section 126, your lordship is aware, it is the actual unauthorized use which is made penalty. Unless it is shown that the petitioner is consuming excess electricity, there is no scope. And there is a judgment of their own appellate authority as an annexure. I have annexed in this petition, which will show that had the entire switch been on, they could have detected the actual load in use. That has not been done simply by counting the heads which are connected through the changeover switch as well as my own genset they have taken into consideration. And the latest.
I do not know if your submission is agreed to, is admitted by them. Supposing they say no, everything was done, then
Your lordship, their bill itself will show, which will include the date of inspection. From there, your lordship will find what is my load in use during that month. That will be reflected from their own bill below. I will take your lordship to that.
I don't know. Yes, they just show me the division bench judgment.
I'll vote the judgment, sir.
And my lord, there is no appellate authority right since January.
There is no appellate
No
authority.
appellate authority.
There is no appellate authority.
Your lordship has recently disposed of my case, my lord,
Correct.
250 Industries. I went there to file my
Correct.
application.
Right now, there is no appellate
appellate
authority.
Perhaps because that, yes, in that it.
Then, if there is no appellate authority, what to do? Then this court will have to decide.
In that case, your lordship can at the most, if they want, let the matter be remanded back to the area manager and to, with a specific direction, whether the load found was the metered load, because that is the low load. If they found that there is a petitioner who are using excess metered load, then they can make an assessment. There is no objection. And that can be done by setting aside his final order.
Whether the load found,
Whether the load found was the excess metered load. In that case, they can undertake assessment procedure.
but how will they do it now?
My lord, bills are there. Bills are there, my lord. Every month, whatever the consumption is recorded, whatever electricity I am consuming, that is recorded in the meter, my lord. Your lordship is aware, there is a CMRI, co-on meter reading is, and the meter operating in petitioner's premises is the demand, static demand meter, which records every data regarding energy consumption, etc. So what was my consumption that is reflected from the bill, because bill itself is issued on the basis of those that recorded in the meter. So what is my, your lordship may kindly take clothes.
Just a minute, just let me read this for the.
Lordship, in that other matter which your lordship had examined a week ago, there your lordship was of the view that that matter was posted after 6 weeks. In the meantime, if the government wants to do anything for
You see,
appoint-
out there in that case, what happened was this court had already directed
yes, that
a
was
few years back
Yeah.
that it should go before the appellate authority.
that
However, when it went before thereafter review was filed, saying that there is no appellate authority. But in the meantime,
again
there was the appellate authority. But when we tried to take up the matter, we found that
again
that person retired.
My lord, actually what is happening, my lord? The persons retiring from APDC, they are appointed. And they are appointed only on a stopgap arrangement. There is no permanent appellate authority for 1 year or 2 years. That is the problem.
authority is permanent. The person who is filling up the post, he has a tenure.
That's the problem.
Yes.
But then there's no one who's being appointed since that person has.
Presently, there is
then
nobody.
What to do?
Perhaps this
So
matter,
there is no authority as such.
presently there is nobody holding that.
So that leaves us with the only available option for him is to this court.
But since otherwise the issue is very technical, Your Lordship. If your lordship was
Slightly technical.
very highly technical, Your Lordship.
Yes, that is why I am saying that this matter be remanded back to the area manager who passed the order.
That
I have to first understand the issue properly. I cannot just, because I don't understand, saying that since you know it better, please reconsider this issue. I have to find out whether there is a case for reconsideration. If I had understood everything properly, then okay.
Your
But
lordship,
then, how long will you take to make me understand?
it will take some time.
That is what, no. I can, pretend to agree with you without knowing anything. That will not be doing
My
justice.
learned friend cannot dispute it, my lord. Because ultimately the decision is there and it is dependent on the load registered in the meter. Then and then, my lord, and the
The
close of-
load registered in the meter will be by the numbers that come out, correct?
Yes, my lord, this is digital meter.
That's the digital. Okay,
Yes.
there is another kind of measuring
No,
meter.
analog,
my lord, there
the
is,
old analog meters are also there.
and there is.
They're all
Now,
meters.
most of
They're
them are
all meters.
Yes, those are all static meters, my lord. And the data is stored,
Ah.
a memory chip is fixed in the meter, my lord. Data is stored in the meter is downloaded by using CMRI. So each and every,
No, even without that. So your electrical bills gives you the number from which it is counted and the subsequent number on the date of
date of
checking.
filling this.
And then the difference between the two is the load that you have used up
yes.
for that month.
Yes, exactly,
And accordingly, you pay according to the units consumed.
yes,
I mean, that's the general
yes,
way of looking at things.
exactly.
So according to them, you have been using 840 kilowatts of electricity.
Yes,
And how is that proved?
by counting the heads of the machines, not the meter reading.
Okay. By counting, what would be the output without going into the issue of what was the actual consumption?
Without looking at the meter reading.
Without looking at the
Yes.
meter reading, on the basis of your machinery and all your plug points or whatever.
And there is another issue, my lord. My transformer capacity itself is 500 kV and there is a judgment that I cannot use more than what is the transformer capacity because.
No, I don't think that's
Yes,
correct.
there is a judgment of our right.
But is that correct? According
Yes,
to
my
you?
lord. I can.
No.
I can use
Some
5 to 10%.
extra. It'll
But-
be there.
But in case, as against 500 kVA, which is equivalent to 425 kilowatt load, kVA can be converted by multiplying the same with 0.85. That is the provision also, madam. So I cannot use 425 kilowatts and they are releasing 840 kilowatts.
I don't know, some machines might be able to do it. How do you know?
No, my lord, they themselves permitted me to run.
Look, I can understand if a technical person said it. But I don't know if we are equipped enough, judges are equipped enough to know whether a 500 kVA transformer can take only 5% more than the load that is written there, or it could be more than 50%. We do not know.
My lord, their provision is there, my lord.
Okay.
Provision is there, as well as they themselves considered before this report in another case, my lord, in 2020, 2000 itself.
What I understand from your submission is this. Say you build a house and electrical connection is given to the house. Now the load that is expected to be consumed is on the basis of the number of plug points and switches that are there in the house. And on the basis of that, there's a minimum rent payable or the minimum electric bill.
Now they demand charge me.
There's no more, that is
No,
gone.
minimum charge is not applicable.
Okay.
My lord, because it depends on the connected load I have taken. I am liable to pay on the basis of the connected load
Connected
or
load,
the contract demand.
but supposing the connected load,
Yes.
supposing you use less, what do you mean by connected load? What is the meaning of connected?
Connected load is the sum total of all the energy consuming devices which are connected with the supplier's mains.
But supposing you don't use those devices.
Yes, then there is a provision for entering into contract demand agreement. And that provision is there in the schedule of tariff. I can enter into demand related contract from 65% to 105% of the connected.
I thought it would be less. No,
I can
go less also.
less
go
also
upward.
and
Upward
upward
also.
105, because if there is any excess use, then there will be strain in the system. So I cannot use more than 105. Up to the extent of 105 kVA, I can use. That is the low below. And as far as domestic is concerned, there in the tariff, schedule of tariff framed by the AERC, it is specified 1/3 of the load is to be subtracted. Because all the points are not used.
No.
That is in respect of domestic.
But but then the electricity is calculated on the amount of electricity used as per the
Yes.
meter reading.
That is meter, yes. Yes. Your loads will
So,
find from
so
last
where is the question of subtracting 1/3? Just because it's a domestic.
domestic they are permitting.
So supposing you use a certain load, say 100 units or so, they'll deduct 1/3.
No, not on the basis of whatever the units are registered in the meter, I am liable to pay for the same. It is only in respect of the connected load. Only in respect of the load. If I take, say, 10 kilowatt, but from the meter reading, it is revealed that I am using only 100 unit. Whereas if the table prescribed in clause 6.2.1.1, it is seen that my consumption should be 1,200. In that case, my lord, I can ask them to reduce my connected load by entering it into a contract demanding.
But the amount of money you will pay will be on the basis of the actual consumption, no? Or on the
But-
load.
Two-part tariff. One is on the basis of the unit consumption, and second one is the fixed charge or the demand charge.
But how do they reconcile? It will be two different.
That is reflected in the meter.
Reflected in the
Yes,
meter.
yes.
But in the meter, there's only one reading.
Both the readings are reflected.
Okay, and there's a way of calculating it.
Yes, that is reflected, and that is meter is equipped with recording all these parameters.
So in your case, what has happened?
In my case, the meter shows by total that you also will find. page 43, your lordship.
Yes.
Your lordship may kindly come to this portion.
Yes.
MD,
Huh?
MD KVA,
RD KVA.
MD.
MD KVA.
MD means maximum demand recorded by the meter is 283. And your lordship may kindly see contract demand
Maximum demand.
recorded by the meter.
What about it? Huh.
And your lordship may kindly see the contracted demand, 320 KVA.
Yes.
And the connected load is just before that, 418 kilowatt.
So what is
whatever,
it? Huh.
whatever the units consumed by me that has been billed separately, and since I have entered into a contract demand agreement of 320, even though the maximum demand recorded by 283, they charge me on 320 kV. That you'll, because that is the contract demand. Though my meter recorded 283,
Though it is higher also, whatever.
then also I am liable for the
320 only.
320. So from this bill, this includes the date of inspection that shows that my total consumption during that entire month was only 283. So where from they are saying that I have exceeded the load to the extent of 840 on the basis of their own document.
But KVA and kilowatt is same. It's different.
Different. No, below the unit, these are the units of consumption.
Okay.
KVA can be from connected load, we can convert it to the KVA by multiplying it by power factor of 0.85. And if it is reflected in kilowatt, then we can get the KVA by dividing.
0.85, 0.85.
Yes, my lord, that provision is there. May I place it?
I think I'll need another another session with you. But I'm starting to get a little bit. Little bit is making sense now. But so the meter reading showed that the actual consumption is less than the contract
That
load,
is contract demand.
the contract demand.
Yes, my lord.
Though it is, and the contract demand also is lesser than the connected load.
Yes, that is also lesser than the connected load. Because as per the CD load theory,
And the connected load will be as per the transformer load? No, that will be different. That is only the capacity of the
they
transformer.
cannot permit any excess connected load
Ah.
beyond the capacity of the transformer. Your lordship may kindly come to page 5, 4 and 5, 5 million,
It's 5.
page 5,
Yes,
close B.
yes.
The manufacturer's ratings are generally expressed in kilowatt or HP, that is horsepower. If the ratings are in KVA, they should be converted into kilowatt by multiplying the KVA with power factor of 0.85. If some or any of the apparatus is rated by manufacturers in HP, this shall be converted into kilowatt by multiplying it by 0.74. So the conversion procedure is prescribed.
Anyway, I think it'll take some time to fully understand from, and I need that, I think at least another 2-3 sessions, I think, to understand it fully. Do you think so?
No, my lord, in fact, from the bill itself, I can say, nevertheless,
Otherwise, your lordship, the supply code says that the act of even exceeding the authorized load, if the connected load, even if it is not in use, exceeds the authorized load, that amounts to unauthorized use of electricity.
If the connected load,
Exceeds the authorized use,
but connected load, who gives the certificate that this is the
Yes,
connected
in
load?
this matter, in this case,
It'll be you only.
yes, we conducted a load survey in the premises, in the presence of the representatives of the consumer, and we found that the connected load was 840 kilowatt, while the authorized load was only 418 kilowatt. Now the supply code, it was,
But at the time of initial connection,
yes,
electricity connection given to him, At that time, the connected load would have been calculated by you all.
Yes, it was 418,
Okay, that was 400.
418. That was what was authorized to him.
And
when we-
thereafter, you all found that it had exceeded by 50% or
Almost
100%.
Almost 840.
100%.
Yes.
But he says that that is based on the basis of the
He's
The
saying that
various
these are the
machinery.
appliances
Appliances,
connected in
machinery
devices but not in use, basically.
Ah.
But the supply code, which was in force then says that if the connected load is, the detected connected load is more than the authorized load, that amounts to unauthorized use of
Okay.
electricity.
That provides metered load. The word metered, if the load detected is metered detected load is excess than the authorized load, then
Is it?
yes,
Metered.
your
Is that word metered there?
The language is
Milord,
subject to the-
5.4.1.
no, it is 5.8, 3.2. It says, subject to the generality of the above, cases mentioned hereunder shall be generally treated as malpractice. Clause B is exceeding the connected load authorized by the supplier. That is all it says.
But how do you know what is authorized? So he says metered load.
No, that
Clause
is what it says.
5.4.4.5.
Clause 5.4.
Clause 5.A.4.1.
4.1.
Use of unauthorized electricity load exceeding authorized connected load metered.
No. The metered is for the entire heading is metered. It is not only for connected load because it is after the colonial lottery.
Look, this is
The word metered had anything to do with connected load, it would have been before the colon.
And you are reading 5 point?
5.8.3.2 B. Just on the same page on the top, your lordship.
Okay.
Because there is also unmetered use of electricity. That is also theft. So here the word metered means you have not interfered with the meter, but it still amounts to unauthorized use of electricity. And there is another kind of unauthorized use, which is completely unmetered use of electricity.
Lord, I have placed one judgment of the AERC, which framed the supply code. They have clarified. You know, see my kindly syntax judgment I have placed. Only para 9 minutes. Clause D.
Yes.
This is similar provision that was there, my lord.
No. Clause para 9B.
9D.
D.
Clause 7.4.2 of the ARC electricity supply code regulation will be applicable when unauthorized use of electricity is detected by the assessing officer. Excess connected load cannot be termed as authorized use if the maximum demand record shows otherwise. My maximum demand shows that this is only 283. So this is the clarification because there was dispute all along. There was a dispute. They were not taking into consideration the meter load. They were proceeding. That as far as the clause 5.8, that is a malpractice, my lord. So that requires regularization. But for penal provision 5A41, because this is the method prescribed only in case the consumer is found indulging in unauthorized use, then and then that will be metered. Then and then this clause 5.8, because the penal bill is issued as per clause 5.A.4.1.
So it's so what you're saying is that what has been detected is not an unauthorized use of
Yes,
electricity.
my lord, because this is
It's only a malpractice.
not mal.
Huh? Is it a malpractice?
My
It's a
lord.
malpractice, is it?
They, my
What
lord,
is the difference between malpractice and unauthorized use of electricity?
my lord, malpractice, my lord. If in fact the consumer is found indulging in actual unauthorized use, then he can be subjected to the penal consequences. But if it is only the connection simpliciter without any use, then he can be asked either to remove it or to regularize. These are the two options available. That is from
Okay. So basically, okay. So according to you, the excess connected load that is there, that has been found in your premises, there can be no penalty against it.
Milord, their own document will show that those were authorized by them, Milord. The document is there, Annexure 1 and Annexure 2. Changeover switch arrangements were provided, and this electrical inspector authorized the petitioner to run its generator sets, Milord, because they are not in a position to provided.
Change over switch from one electrical line to another.
Yes. Please. That is document A1 and 2, my lord, NH.
Anyway, I think we'll take it up again. But just, you see, what about this? He said excess connected load cannot be termed as unauthorized use.
I'm not aware of that. I'll just take a copy from my.
You just look at
I'll
this.
just have a look.
Because 9D.
I'll just have a look.
So that, I think we'll have to go, one day we'll have to sit and, hear you completely on the, right, what do we say? On the prayer of the parties list the matter. When? After 2 weeks. You filed an affidavit in the meantime?
Yes, sir.
In the meantime, Mr. KP Patak shall
Lord,
file
one-
affidavit.
3 weeks time, my lord.
At 3 weeks, we shall file affidavit in WPC 4538. 4538 of 2016.
Deeply aware.
In next case is exactly similar.
Yes, same both together.
But in that case, they
No,
have
no.
filed affidavit in
I know,
opposition.
I know.
I also filed my reply.
Let me file affidavit in this, so we'll dispose it of both together.
Yes.
It's, one order only. One order. 3 weeks.
May please, here, confiscation proceeding records, we will get it in few days. Lordship may fix it on Tuesday, Lord.
You're not going to vote.
After 7, my lord. Thursday, Lord. After 7. Okay.
The truck has been released.
No.
Truck is with them.
Yes.
But firewood, I think is, how do you say that it's not wood?
Oh, after such a period, my lord, I am now waiting for whether notice was issued or not. They have stated in their affidavit that confiscation proceeding has been started.
Yeah.
We have not received any notice, and today, my lord, I don't have any instruction whether they have issued notice or not.
Have you started the confiscation? You have started the
Yes,
confiscation
Lord.
proceeding.
That is why I will be able to produce it, lordship, by after.
Auction, has it been, they are going to auction the wood or not?
No, still they are auctions.
Okay, right. Mr.
I bought it.
I. Thakur is granted 2 weeks time to produce the records. List the matter on. List the matter after 2 weeks.
My lord, a date may be fixed, but otherwise.
Give a date.
Yes. All right. This is probably become infractuous. It is covered by your lordship's decision, my lord. The prayer in the petition is with regard to renewal of the vending licenses of the petitioner. After coming into effect the 2017 capping policy, my lord, renewal is no longer permissible, my lord. This is covered by your lordship's decision.
23. This item
14, my lord.
for 14. Item for, yes.
But they will not come, my lord. This is
I think it's a covered matter.
covered.
So, yeah, right.
I have underlined the relevant paragraphs. In fact, it went up to the division bench also declined to interfere. Not your lordship's decision, other decision.
No, no one appears for the petitioner. Petitioners. Person. Mr.
Be sure.
B. Sharma appears for the railways and submits that this matter is covered by the order dated 31/3/23 passed in WPC 1828 of 2023. which was disposed of in pursuant to order, judgment and orders passed in WPC 5313/17, 5143/2014, and WA number 47/2023 and 54/2020. In the order dated 31/3/23 passed in WPC 1828/2023. It has been stated that there is no clause providing for extension of licenses for running catering units / stalls beyond 5 years under the catering policy of 2017. So on the other hand, the case of the petitioners herein is that they had been given their licenses on the basis of the catering policy of 2010
They were allowed to continue. with the-
and were allowed to continue thereafter. So, however, in view of the catering policy of 2017, the stand of the petitioners appear to hold no water any longer. Para, the operative, para 18. Now, this court further held in the order dated 13/1/2023, passed in WPC 1828 of 2023, that persons who have catering vents / stalls extended beyond 5 years in terms of the earlier catering policy of 2010 cannot have any legitimate right to have their catering to have renewal of their license in terms of the catering policy of 2017. Next paragraph. The above being said, comma, as no one appears on behalf of the petitioners, the writ petition dismissed as for non-prosecution. Better that way, for non-prosecution.
This bit relates to the fisheries improvement matter, starting matter, I like to draw attention matter, have a look the order date, 26/4/23.
26/4/23. 26/4/23.
Paragraph 5.
Yes, so comparative statement was to be made. So it was made on it.
They have to ascertain, my lord, whether the first comparative statement was prepared or not, my lord. And all the societies, my lord, exceeding the petitioner society, the labor bit was examined or not. They need to have place with the. If it is there, my lord, then I will start with the.
If it is not there, then they have got to make a fresh.
No, my lord, again, my lord. They have to bring it, my lord. Otherwise, my lord. case-
Yes. Where is the comparative statement?
That's a government. I'm the private party where settlement was made in my favor. He came, my lord, once your lordship will kindly take in notice, this of 2019. He came to the court in 2022. There was some proceeding which was going on, other. So he was behind the fence.
Oh, my lord,
And looking into it, kindly see.
Court, my lord.
No, so on the basis of the fresh comparative statement, you were selected,
Yes,
is it? On the
Yes,
basis
yes.
of the fresh
at
comparative.
paragraph 4. Preparation of a fresh comparative statement according to law by taking into consideration guidelines contained in the communication, all other relevant guidelines. Contained in communication of internally contained direction of causing an inquiry on the aspect of neighborhood so as to come to a definite.
Yes, who is
conclusion.
appearing for the thing, for the government?
Oh, my God.
There is no comparative statements there in the record, but there is no date is there, madam.
No dates.
No date, madam.
That-
No date.
Deadline. Forwarding report.
In the meantime, our qualified.
This coming.
Forwarding. Program.
Deputy Commissioner, Deputy Commissioner. Next.
I think my learned friend should check it properly. That's the issue.
So what to do?
No, let's see, let him check it. We have to see whether some records, I don't know.
Even matter. Okay, so handle by matter, senior matter.
Lossi may, today, tomorrow that Lossi will go through it, Lossi. Any day, but today, no, no, no. Even Lossi, it's reflected that that is not there in 1-2 document, Lossi. So Lossi may give, sometime Lossi will go through it.
All the intending teachers, like the two participants.
It is different.
But there is a case, matter, there are not for-
Huh?
They have services. So I am the highest. What they did, my lord, they did particular two participants. They have the position is 25 lakhs. I offered
Yes, ma'am. I go for it.
How much? How much?
56.
56.
More than that. They have certificate. So,
You should have given 25 to that.
so what I said, my lord, if they do not come with the appropriate manner, and there is no order holding it from the court. You go and.
Anyway, unless the thing comes, unless they are able to find the, so if the comparative statement cannot be found, then what happens?
And the only question remains, number one, my lord, where the neighborhood certificate is very important. Neighborhood certificate is.
No, forget that.
No,
If there is no comparative statement,
So comparative statement will reveal what is the amount that has been given by him and what is given by me.
correct.
Apparently, it is higher. Let us say, we say it is high. Apparently, comparative statement to compare. It is only to the extent that what happens if a neighborhood certificate, second aspect, what happens if a neighborhood certificate is not given? That part is, my lord, he is higher. Undoubtedly, I am saying I have checked it, and it is settlement order itself speak that he is higher than me. Settlement order. So comparative settlement say who is higher, who is lesser. He is higher. Next question is that why they have rejected? Because there is no neighborhood certificate which has been produced by him.
But is that an issue any longer?
The neighborhood certificate. But today, that if neighborhood certificate is not given, then it's the end of the matter. If you put a higher also, that's the immaterial. My name, this is,
Notification says, my lord, government notification says the circle officer has to visit by himself. And there is already,
No, he's saying that neighborhood certificate that you have not given.
but no, he has not also given.
He has
That's
Nobody
that,
has given, that's why
Ah,
state notification is that, my lord, you go practically and you bring the distance.
see the distance of what?
Here, distance from the society to the neighborhood on
Okay.
that was not done. There is already order of honorable court of coordinate.
So that has to be written in the comparative statement.
Yeah.
That should be there.
That's why, my lord, honorable court in paragraph 5 on 26(4) categorically asks to,
Yes, sure.
so there are two issues here, my lord.
if they can.
One
show-
is comparative statement. Second is about a neighborhood certificate. Comparative statement, he is higher.
Did you submit a neighborhood certificate?
That's what I have to already, listen, Amit. That's what my learned instructing counsel said. The certificate has been given.
Assuming nobody has given.
We have given.
Even though,
No.
Record.
Assuming he has given, then what happened?
assuming he has given, my lord,
And-
even though circle officer has to
Ascertain what?
a certain neighborhood.
Okay, actual.
Actual neighborhood.
Ah.
As per notice.
So the certificate is not much of value.
No, practically.
Practical.
And plus, honorable single judge of coordinate bench say, go and prepare fresh settlement, fresh comparative state. That also not been done. One my lord, they have given 50% lesser than, more than 56, my lord, and they have offered 25. So more than, my lord, 100% above, I above.
So they can buy Audi car
Yes, my lord.
while you'll have to do with a moped.
Open and old model, not the guy.
Anyway,
Acknowledge today, Lordship, we have to do it. Otherwise, when something is there, Lordship, I have to verify. Lordship.
okay, right.
Lordship, only one thing, my lord. Lordship do not fix, my lord, 10 to 13, I'll be out of.
Then the third.
No, my lord, for the whole election of all of them.
Okay, right.
15, any.
Mr. K. Gogoi, learned counsel for the state government, submits that though he has brought the record, he needs time to locate, trace out the fresh comparative statement made, showing the rates quoted by the tenderers
All tender.
Huh?
All tenders.
and the verification of the distance of the settlement of the settlements of the tenderers vis-a-vis the fishery. List the matter. When?
Lordship fix it, my lord, on Thursday 16.
Is it okay?
That's, okay. Only 17, I think.
Huh?
16 in lordship.
After,
I'll do whatever.
after
I'm not going to be here
I
anyway.
think after 21st, I think it is not inconvenient to your
They are
lordship.
very vigilant.
21st, anyhow, we are very,
Security
I
deposit
know.
is still lying with them.
after 21st, any date, man, which is convenient. After 23rd,
I don't know.
22nd, 23rd,
16 is the convenient method.
23rd,
Man, 25.
22nd.
or
23rd is some holiday.
22nd.
22nd is Wednesday, my lord.
21st.
22nd,
22nd.
21st, my lord. otherwise
21st, my lord, they will, 22nd, it will be 22nd.
22nd is the Wednesday.
It's okay.
22nd.
22nd,
Try your luck.
yes.
It doesn't, if it doesn't happen, you
Or
put it in the
lordship
week.
fix the matter at 2 o'clock, man. Whatever list comes, doesn't. affect. At 2 o'clock, lordship fix, man.
It's okay, his urgency is there.
Okay, at 2 o'clock.
Lord,
They play always.
that's 20.
They're very narrow campus matter. What happened, the, NECL has started a tender, each time for calling for the bidders, waiting bidders for rural electrification. And accordingly, the petitioner participated and, and he was awarded contract. But at the time of the LOA was issued by not, the payment condition was changed. So they have deviated from their own terms and conditions originally days before the NIP matter. Now the pilot similarly situated matter, other contractors also challenge this order and the honorable single judge.
Challenge what order? Termination,
Yes, it was terminated and AMD of 25 lakhs was
forfeited.
So in my case also, my this thing is terminated. I was awarded for package number
So
7.
now you are challenging the termination order.
In fact, my AMD
Are you what are you challenging here?
the order also.
Let us see whether the challenge to the order.
My fair value at page 20.
Yes. Termination email dated 25/11.
Termination action. And in catching of the.
Now, on what ground are you challenging the termination order?
Because they have deviated from their original terms and conditions.
They have deviated.
Yes.
What is the terms and conditions that they have deviated?
Page 32, the original terms and conditions.
Yes,
At a supply erection, testing and commissioning of works at 1.1 may vary by the first installment 60%. 60% payment against supply of various items of price schedule 1, complete items of individual solar home lighting systems, including 100% ESP, shall be paid on receipt and acceptance of the material on submission of the documents indicated here. So, my lord, when the LOA was issued, my lord, to the petitioner, annexure 8 at page 63, my lord. So this letter of acceptance is dated 12/11/2021.
let us see the termination order. Where is that page?
Well, before that, I could just point out two things. Page 64, my lord, signing of the contract agreement down below. After the award of the contract, my lord, what is to be done? Signing of the contract agreement and the down below, my lord, page 64. The contractor has to sign the agreement, then within 7 days has to submit, my lord. Contract performance security of 3% of the contract price salary has to be submitted within 7 days from the date of issuance of the LOA. And where they have.
Where are you reading all this? I don't know, you are reading. Where are you reading all this?
Page 64.
Yes, where? Page is for which page? Top, bottom, middle, where?
64 bottom, my.
Huh?
64 bottom,
Bottom.
signing of the contract act.
Yes.
On the unconditional acceptance of this LOA, the contract agreements that have to be signed on submission and acceptance of the contract performance security within 7 days from the date of issuance of this LOA. Then, my lord, contract performance bank guarantee. The contract performance security for 3% of the contract price shall have to be submitted within 7 days from the date of issuance of this LOA. So, my lord, then on next page, page 65. Roman 2. In the event of non-submission of PBG, that is bank guarantee, within the stipulated period, the award may be terminated and the peak guarantee EMD submitted by you shall be forfeited without any. So, by this LOA contains the terms and procedures of the.
Let us go straight to the termination order, then we know the reason for your termination.
Is at page 78 and annexure 30.
Page 78.
70.
Yes,
I read.
yes.
With reference to the above, this is to inform you that the LOA awarded to you against the work of the rural electrification work in the district of Assam
Oh, you had rejected the LOA.
Yeah, package number 7 is hereby terminated with immediate effect due to rejection of.
Why did you reject the LOA?
Because my lord, they have deviated from the terms and conditions of making payment, my lord. Earlier, it was 60% on the day of we enter into the agreement. Then later on, it was on the physical, that is, what is as the project completion date is release of the installment of 60% progressive payment will be based on the.
Let us see any show cause notice was issued to you. Let us see the show cause.
No, my lord, no software.
No show cause.
So the issue is, there was a tender floated by APDCL for installation of solar power systems across in rural areas under a central scheme. Now, in that scheme, we floated the tender. There was a time frame imposed by the government of India under which we had to complete the installation of the systems. So in the initial tender which was issued, the payment terms were somewhat different. That immediately upon award of the work, they would get some money.
60%.
But in the letter of award that we issued, the payment terms were changed and it was made subject to completion of work. So if you complete 60% of the work, you get 60% of the amount, so on and so forth. That was not there in the initial tender. Now, immediately some bidders accepted the changed terms and some of them objected. Now, what happened when objections were raised after issuance?
No, that changing of the terms was done when?
At the point of issuance of letter of award.
At the point of issuance of
Issuance of
letter of the award.
Letter of award.
Letter of acceptance.
Letter of acceptance. So when the terms were changed, some tenderers, because there were a number of packages, some tenderers accepted and some objected. Now, the ones who objected, since the tender stipulated.
He's one of them.
His case is somewhat different. He stands on a completely different footing from everybody. So the ones who objected, Your Lordship, as a matter of routine, APDCL decided to encash the bank guarantee, the earnest money bank guarantees of everybody, because the tender stipulated that if you do not give an unconditional acceptance to the LOA, then you are liable to forfeit the EMD. Against that termination and forfeiture of EMD, several writ petitions were filed. The first main writ petition was one called.
So they were all allowed.
It was allowed. They were allowed on the principal ground that we had definitely admitted position is that we had changed the terms in the LOA and they had objected. On their objection, we could not have unilaterally encashed the EMD. The termination was not interfered with because the work was already completed. Your Lordship. The termination was not interfered with, but the EMD we were directed to refund. So that was done. Why these two cases, Your Lordship, were left out was specifically because here.
One case, not two cases. 2%.
Two cases.
Huh?
19 and 20. Identical matters.
The same contract work.
Same tender.
Same
tender process.
Same
Package
person, same petitioner.
Same petition. Package is different.
Oh, package.
Packages. So why these matters were left out, Your Lordship, is because whereas all the other bidders had objected, not given any acceptance, he accepted the work.
Oh, he accepted.
Initially, he accepted. He said, yes, we accept the terms and conditions.
How do you say that he accepted?
It is on record. Your Lordship. His letter of acceptance is on record. So he accepts. He accepted.
Page 70.
Now,
Just a minute.
yes, sir.
Yes, page 72.
72 of the writ petition. Now, on the last occasion, Your Lordship.
Just a minute.
Yes.
Just a minute. What is the date? Acceptance date?
15/11/2021.
What is the terms of the tender that
Yes.
60% will be paid?
The amendment with it is at page number 63, Your Lordship.
63.
The letter of award is at 63. with the changed terms and conditions.
And where is the earlier terms?
The earlier terms your lordship will find at
Page 30.
30.
This is part of the NIT.
Earlier terms are part of the NIT. And the changed terms are a part of the letter of award, which is of 12/11/2021.
Okay, so he accepted.
He accepted. Now, my argument was all the others, they had not given any acceptance. So there was no concluded contract.
Correct.
Since we had unilaterally changed the terms of the conditions, perhaps the judgment, what was held by the.
There's nothing wrong with the order.
Yes. Now, in his case, once he has given an unconditional acceptance under section 3, a concluded contract comes into being, your lordship. Now,
Where is the contract agreement?
no, your lordship, though there was no formal contract executed. That is but the position would be that once an unconditional acceptance has been given and acceptance is complete, as against the.
Can it be said to be complete?
There is, your lordship, I remember, I could not find it, your lordship. There was a judgment of Justice Sadasivam, where he has held that once unconditional acceptance has been granted, even without execution of a formal contract is said to be concluded.
Any citation?
Why I was reading certain conditions, my lord, subject to the fulfillment of that condition, my lord, that the contract will be concluded.
Ah.
That is my humble service.
Okay, no, but that was the 32 was changed. 32 was changed by way of page 63. Page 32 was changed by way of page 63.
32 was the payment condition.
Ah.
Now at page 6 is the letter of acceptance.
Yes,
At page.
letter of acceptance dated 15/11.
is dated
12/11.
2021.
Huh?
12/11/2021. And the
Yes,
relevant clauses, my lord, at page 64, next page down below.
yes.
Signing of the contract agreement. When I will accept on unconditional acceptance of the LOA, then the next step will come that the contract agreement has to be signed. And then again, my lord, 3% of security, the contract price has to be deposited, and the bank guarantee has also to be deposited within 7 days. So once the LOA was accepted, the contractor has initially accepted, then thereafter he resigned. On 11/11/2021, he has written when he realized that the terms and conditions has been changed.
Where is that page? Yeah,
Page
yeah.
72, that I have accepted, my lord.
Yes, then after that.
Page 72, my lord. And
Yes,
next-
page 72 LOA has been accepted then.
Yes, ma'am.
Page,
And at page 73. It is 18/11/2021. Now at page 74.
yes.
At page 74, the contractor has written, my lord, we would like to inform that the revision in terms and conditions of the payment after allotment of work shall adversely affect the financial planning and execution of our project, and it shall be difficult to execute the project under the revised terms of payment in such short time. We therefore, with due respect, would like to revoke our LOA acceptance letter and gracefully withdraw our offer bid to you to change of terms and conditions of the payment.
We would like to
Now,
inform that the revision in terms of the condition payment after allotment. After allotment. But then you had accepted this terms and conditions.
Then at page 75, the APDCL has wrote to the petitioner asking him to accept the tender unconditional.
Ah.
Page 75.
Hmm.
May I read it? With reference to the subject cited above, this is to inform you that as per the terms and conditions of LOA issued to you, you have to confirm your unconditional acceptance of LOA. Therefore, you are requested to confirm your unconditional acceptance of LOA within 2 days of the receipt of the email for execution of the project, failing which the necessary action will be initiated as the document. So thereafter, when I am not accepted at page 78, they have issued the termination letter, my lord, email.
Yes.
Page 78, man. The email is dated 25/11/2021. With reference to the above, this is to inform you that LOA awarded to you extensive work of this rural electrification work in district of Assam. So new scheme under the package 7 and 16 is hereby terminated with immediate effect due to the rejection of LOA from your end. My lord, my humble submission is the contract has not been not concluded, my lord, because I have to perform, I have to execute the agreement and I have to deposit the 3% security, my lord. As
So
stipulated.
termination, the LOA has been terminated.
LOA has been terminated.
So that I have not executed the agreement as per the LOA and no, neither have deposited the 3% security as stipulated in the LOA matter. So my humble submission is that this contract has not concluded. It was still on the initial stage, my lord. The hearing is similar in the similar matter, my lord.
Yes.
Decided the matter by the favor of the contractor where paragraph, I will rely on paragraph 23.1. Page 25.
Page 23.
25. Technical matter also the same NIP.
23. 25.
25.
Yes, Farah?
Para 21.4. May I read it?
Yes.
The issue whether a concluded contract had been arrived at by the parties is also dependent upon the terms and conditions of the notice and writing tender and the tender document herein. The letter of award issued by the employer in favor of the petitioner as successful bidder and conduct of the court. The letter of award was issued stating the LOA was issued to the petitioner for package number 8A as per the rate specification, instruction and terms and conditions of the stipulated in LOA A. The LOA mentioned the total contract price, pending note A, note to the LOA wherein the terms and conditions were set forth, while annexure A to the annexure O, and the respondent will be detailed from the successful bidder.
Yes, carry on.
On unconditional acceptance within 3 days from the date of issuance of the LOA, the petitioner would be required to submit contract performance guarantee for 3% of the contract price within 7 days from the date of issuance of the LOA. The LOA further content that in the event of non-submission of PVG within the stipulated period, the award might be terminated.
Go to the operative portion. Don't go to the facts of the case.
At paragraph 2, paragraph 22, in view of the finding this, there was no concluded contract between the petitioner as the successful bidder and the employer. That is the finding matter on the concluded contract. Where it has been stipulated that 3% more ought to have been submitted and the agreement has to be signed by. In my case also, no agreement was signed and it was not deposited. After my acceptance, they have issued another.
Where does it say that the,
There are 22.
okay.
In view of the finding this, there was no concluded contract between the petitioner and the successful. So, my lord, in my case also, there was no agreement entered by the between the parties. And this 3% was also not deposited as per the LOA. And more so when I have accepted the tender, the respondent have issued letter, kindly you accept unconditional. Then they have given another option to me. Kindly accept the unconditional acceptance by me. Then I rejected. Withdraw my plea and requested to refund my earnest money.
That's all. Anything else?
Contract can be said to be calculated only when there is an ad item and there is parties have entered into the
Where
contract.
does it say that?
No, that is my service that they only have into one thing the bank of the on the court. I will have to go through it, madam. Constituency 5, say 541. Karnataka Power Transmission Corporation.
What does it say?
It says that when a contract can said to be completed only when the parties are admitted on all essential terms of the contract. My lord, my humble submission is that there is no completed contract like this.
Let us see, just a minute, let us see the 32. 32 series. Yes. What is that other,
Yes.
those writ petitions? Give me one.
I'm emailing your lordship. I found this, and thankfully I found that judgment. There is the first judgment which I'd like to rely upon your lordship.
Just a minute.
The judgment of Union of India versus N. Murugesan. It is 2022 2 SCC 25. 2022 2 SCC 25. There in paragraph number 18, your lordship, if scope of section 3 of the Contract Act will discuss. Paragraph number 18.
Paragraph 18.
18. your lord.
Yes.
Section 3 of the Act concerns itself with an act of communication, acceptance, and revocation of proposal. When an offer is made, it is required to be accepted by the receiver to partake the character of a concluded contract. Hence, the knowledge of the terms of the offer is a primary and essential factor for acceptance. To understand this better, when an acceptance is made in an unqualified manner, it takes in its suite the said acceptance, along with it, the knowledge of the terms of the offer. This is for the reason that an unaccepted offer creates neither any right nor obligation. Such an acceptance as existing under Section 7 of the Act must both be absolute and unqualified. As per Section 8, the performance of the conditions of a proposal or the acceptance of any consideration for a reciprocal promise, which may be offered with a proposal, is an acceptance of the proposal. Hence, an absolute and unqualified acceptance would give birth to the contract along with the terms of the offer. Here, your lordship, he was aware of the contents of the LOA.
No, but where does it say that it does not say that unless, even if it's not written down.
Yes, this other judgment says so, your lordship. I'm just sending it. 49.
So according to you, even in the absence of a agreement
Yes.
signed between the parties,
Yes.
it is a concluded contract.
The other judgment says that once formal acceptance in writing or orally is concluded, without execution of the formal agreement, the contract can be settled. I'll just read out the relevant part. The citation, your lordship, is 2010 3 SCC 1. The name of the judgment is Trimax International versus Para 49, your lordship. Para 49, it reads, in the light of the details which have been extracted in the earlier paragraphs, I am unable to accept the stand of the respondent. It is clear that if the intention of the parties was to arbitrate any dispute which arose in relation to the offer of 15/10/2007, in the acceptance of 16/10/2007, the dispute is to be settled through arbitration. Once the contract is concluded orally or in writing, the mere fact that the formal contract has to be prepared and initial by the parties would not affect either the acceptance of the contract so entered into or implementation thereof, even if the formal contract has never been made. So here there is a specific arbitration clause. Now he has because the contract has already come into existence, he has an alternative remedy where to show that there was no consensus or item, he'll have to lead evidence and we will dispute that, your lordship.
Yes.
So the arbitration clause, your lordship, was not on record because only specific extracts of the agreement was next. I have the arbitration agreement with me, your lordship.
Mr. Counsel, I think better you go for arbitration.
My lord,
Well,
in our case,
this judgment seems to be against you.
but in our case, the LOA contains the terms and conditions, right? And when thereafter it will be terminated.
So that
It says, my lord,
Yes,
post
please.
signing of the agreement, then performance guarantee has to be given, and if I fail, then only they will.
where is your letter asking them for the performance guarantee? What performance guarantee?
It is there in the contained in the LOA itself,
Stating?
stating that after this, you have to sign the contract agreement. Then you have to provide the 3% bank guarantee. And if you fail to submit it within 7 days, then your terms, your LOA will be terminated. So it is preceded by
Page?
page 64, madam. What is has been held by the learned Singh and the honorable President with
The contract performance.
page 64 down below, ma'am.
Did you submit all this?
No, ma'am. Because after when I accepted it and then when I realized that there is a change in its terms and conditions, then I have requested for a to withdraw my bid. Then they have again written me a letter that kindly accept the tender unconditionally.
Lordship, this is the original
Not
judgment
have written.
in respect of all the other petitioners. So there, the factual distinction is, lordship, it will be evident, your lordship, what has happened.
Here is the finding of the learned Singh and has been accepted by the honorable President
Yes.
of our high.
Paragraph 8.1, your lordship.
Paragraph
8.1.
8.1.
Other facts all same, your lordship. And there was change in the terms and conditions in the LOA. At paragraph 8.1, if I may read. As per the contention of the petitioner, the court is recording the stand of the petitioner. When it scrutinized the LOA after its receipt, it found changes in the terms and procedures of payment apart from truncation in the period of completion of the project. The petitioner had contended that the terms and procedures of payment contained in the e-tender document had undergone changes in the LOA to the detriment of the petitioner, who emerged as a successful bidder. As the respondent, APDCL authorities by the letter of award had asked the petitioner to convey its unconditional acceptance with changes in the terms and procedures of payment contained in the e-tender document. The petitioner responded by an email dated 17/11/2021, inter alia highlighting about such changes brought about in the terms and procedure of the payment. It also projected that a period of 3 months would be necessary to execute the project, whereas only a period of 5 weeks was made available to the petitioner. By the said email, the petitioner has asseverated that, as I think it could be asserted, that there was alteration in respect of the terms and procedures of payment and the period of completion in an unilateral manner. The petitioner by the said email conveyed its conditional acceptance of the LOA with the request to withdraw the question clause and to send the petitioner a revised LOA. Now, in this matter, he has given an unconditional, unqualified acceptance, saying we accept the term. Now, this is a public limited company. He's not a small contractor, Your Lordship. It's a public limited company. When they receive an LOA, it is assumed that they have gone through all the terms and conditions and then they would respond.
Correct.
So that is why on the last occasion, an opportunity was granted to my learned friend, if possible, to distinguish Section 3 of the Contract Act, Your Lordship.
So right now, you are not paying him what? Earnest money.
We have forfeited his earnest money.
Can you forfeit earnest money?
No, under the terms of
What does the NIT say?
the NIT says, Your Lordship, that the bid security may be forfeited if the bidder withdraws its bid during the period of validity specified by the bidder in the bid form, or in the case of a successful bidder, if the bidder fails within the
Bid security, sir, earnest money is bid security.
earnest money,
Where is that? Where is the term condition in the?
it is at clause 12.6, Your Lordship. Next question. Your Lordship, it is not there in the petition, but I have the tender. Your Lordship. If I may read it out,
Yeah.
it says,
Why don't you put everything here? Why you
The bid
bits and pieces
security-
you put?
the bid security may be forfeited in case if the bidder withdraws its bid during the period of bid validity specified in the bid form. And number B, in the case of a successful bidder, if the bidder fails within the specified time limit to sign the contract agreement in accordance with the bidding document, to furnish the required performance security in accordance with
Yes,
bidding document.
That's relevant.
in opposition pay and page 120, madam.
And this
Hello, it is in affidavit in opposition.
arbitration clause is also, I have just highlighted the relevant clause. So that is contract clause 12.6.
22.6.
No, 12.6. I think the page was, it is the other page. That is not it. I just highlighted clause 12.6.
You don't appear to be having a very good case. Because of this clause. And the judgment of the Supreme Court. In Trimex. Where is that? Tara?
Para 49. There is a copy there.
49, no?
Yes, sir.
What is the citation?
The citation is 2010 ESCC 1.
Why don't you go for arbitration? Better. I think you'll have a new lease of life.
I will have not the option but to go for the arbitration if your lordship.
I think better you go for arbitration.
But my humble submission is that, that
I can decide the matter, no problem. But it'll be my
Now, of course, your lordship will held that there is since there is being a arbitration call and this line of argument is also that since it is a concluded contract, he has to approach arbitration.
but the other thing is that arbitration, there's no contract agreement has not been signed, whether the arbitration clause will be applicable.
So, but in the light of that Supreme Court judgment, in fact, section 11 was under consideration in that in Trimex option. There, one of the parties held that since there was no formal agreement, but Honorable Court has held that once the acceptance is there, the arbitration clause will also come into being. Yes, and in this tender, your lordship, clause 22 is the arbitration clause. I have highlighted that at page 62.
But out here, was there any contract agreement signed between the parties?
No, your lordship, contract agreement was not signed.
No, with regard to other disputes, it might have been there. Maybe the arbitration clause was not there in that agreement.
In Trimex, your lordship.
Yeah.
In Trimex, your
The
lordship.
problem is you gave me only one page. Very long judgment. Okay.
Lordship, because even I just remembered reading this about this judgment about that relevant portion, but the issue was regarding section 11 of the arbitration and conciliation and the dispute, if I recollect properly, is that the parties said that since there was only a formal acceptance in writing, I think by email, and there was no concluded contract, no formal contract, there was no arbitration clause. The court rejected it, saying that once a formal agreement, formal acceptance
Once
has
the
been.
contract is concluded orally or in writing.
Yes, then the entire contract, including the arbitration clause, would come into being. And here it is a clause 22. It is in that volume that contract which.
Yes, Mr. Counsel.
One last recourse, my lord, that again I will read it, the 12.6, my lord. That my learned
Yes.
friend has referred.
Yes.
Bid security may be forfeited if the bidder withdraws its bid during the period of bid validity specified in the bid form. Here, before the settlement, before the issuance of the LOA, if I withdraw it, then it will be, my EMD will be forfeited. Now in B, in case of successful bidder, now I being a successful bidder, my lord. If the bidder fails within the specified time to sign the contract agreement,
in accordance with the bidding document. My lord, in case of the successful bidder, I am now here a successful bidder.
Yes.
If the bidder fails within the specified time limit to sign the contract agreement in accordance with the bidding document. Next, my lord, to furnish the required performance security in accordance with the bidder document. So if I fails to sign the agreement, my lord, and if I fails to furnish the required performance.
So you have failed to sign the
No,
contract.
no, my lord. No. Before that, I withdraw my bid, my lord.
Correct.
Because the change in the.
But you had accepted that knowing fully well. You had
But
accepted all
but LOA says otherwise, my lord. LOA says that. LOA that way I have read it out, my lord, at page 64. Signing of the contract agreement, then contract of the performance bank, and then the termination clause comes, my lord.
Okay.
It
right.
doesn't say that if I withdraw, then my EMD will be terminated.
Okay,
And that has helped by the-
okay, we will not send it to arbitration.
And
We'll,
that-
we'll
that has
decide the
been-
matter.
and my lord, that has been held by the
Mr.
coordinate bench at
D. K.
paragraph
Singh, learned counsel
31.4,
for the bear dismissed. Next.
Oblige.
Mr. K.B. Patak, here for respondent number.
I'm for all the responses. Except one. One is State of Assam has been made a party, but it's a formal party because
Yeah, for all the respondents.
not for one. Not for one.
For all the respondents except for respondent number 1, who is represented by
The government,
Mr. M. Chetty. Ah.
Item 21.
Please, your lordship. This matter, basically, your lordship, it's a non-payment of contractual dues, but there is a little bit of twist in the matter.
Item 21.
20. Here, your lordship, the basic issue was the work order was for protective afforestation of Ahora village. So it is.
Another thing basically.
Yeah.
They were saying. Okay, yes. Work completed.
No, yes, everything was, work was completed. I was given the certificate of completion. My amount was referred to be released by the fund was to be released. Everything was done. Then I came before this honorable court. And after I came before this honorable court, then they have taken a different stand. Now they are taking a different stand in this court to deprive me of the. That is what I am trying to point out. That it was for 45. I will just take your lordship to two things. That will be very clear. Your lordship will kindly take up page 16, 1/6 of the writ petition.
No, they have not admitted this due, is it?
Yeah, they have admitted initially. Now,
Initially?
yes, they have admitted the dues. They have
Where in
also
their
forward.
affidavit? In their affidavit?
Yes, then they have.
Where? Show me the affidavit.
That is why their affidavit, they have filed one affidavit and an additional affidavit. That is why. So some twist is there. That is what I am trying to point out. Your lordship will find in the affidavit, they have taken a view that only 80% has been done.
Which affidavit?
Their first affidavit that they have filed.
3/1/2023.
3/1.
2023.
This was the first affidavit. Then they have filed.
Which para? It's 23.
No,
Para 5.
They said
80% of the work was completed by the petition, but as per tender, the work should have been completed by the cutoff date 26.
this is wrong, your lordship. Absolutely wrong.
But-
I'm just to point out that.
But these aspects, so whether in a writ petition we can decide.
No, I'm not going on that. I'm just pointing out. That is why I'm showing just your lordship page 16 for a moment. 1
Page?
minute, page 16, 1/6,
Of the writ petition.
writ petition. So this is basically the project, and your lordship will kindly turn to page 19. I'll take it much shorter for your lordship's convenience. Let us take up page 19. That will be easier. This is what I have to do here. This is detailed estimate for protective afforestation at Hahara village under so and so, so and so, so and so, as per the PWD schedule. These are two parts, your lordship. First part, your lordship will see from 1 to 13. From 1 to 13. This is the part I have to do. Then comes the second part. This is the 80%. This is the 80%.
Okay.
Second part. That is from 14 and 15. 1 year maintenance. So what I have to do, this 80% I have to do the plantation. Then the 20% is maintenance for one. So I have completed this 80%. After completion of the 80%, what they have done, they've cancelled the project.
Oh,
They cancelled the project. Now, after cancellation of the project, obviously, I don't know what happened to the fund. Thereby, they did not pay me. When I came before the on-group court, they initially said that you have done only 80%. I have shown that only I have to do 80% because subsequent 1 year maintenance I cannot do because you have already cancelled the project. So I pay me that amount. That is the basic case. This total amount I am asking for 6 lakhs something that
you are asking for 6,20,000.
that is
But then out here 611.
this is 6
How do you reconcile?
because there must have been some escalation because what they have given the report, then your lordship will kindly see the
So
report.
according to you, you have not been given anything till now.
Nothing. They didn't pay because this is only for 45 days.
This is on the basis of a NIT or tender or what? What is
It's
it?
on the basis of a tender. I am a qualified tender. I was given 45. The period is 45 day. On the 44th day, I have completed. Then on the 45th day, they have visited. They found everything to be correct. It is only planting of saplings that was done, and the fencing has to be done. This was done. In fact, what has happened? I have given photographs. The minister, the forest minister, was present. She was at that time, when the lady was there. She even planted one sapling. Photographs, lot of everything was done. Then I completed 45 days. Now, after 45 days, what they have done, this was cancelled. The project was cancelled. Now, they are not paying me for that account. Now they are taking some 80%, 20. What is the, give me that 80% because I cannot do the next 20% because they have already cancelled the project. Now the question arises, what they have done by the additional affidavit. In the additional affidavit, there's a direction by this honorable court that you file your affidavit or instructions. After that, that is after 4 years, of this plantation, your lordship, they went to that particular place and found that there is a lot of jungle. Somewhere the fence is broken, and that is what inquiry has been done and found that these things have happened. After 4 years in a plantation in a jungle, what you will find? That too in saplings, without even taking maintenance for any
Is
of the
there
saplings.
any completion certificate or something?
Yes, that was given. That was given, your lordship will find that at page 29. 29. Everything has been given. 29. Completion report for sanction works.
Page 29.
20.
Yes.
Before that also, your lordship, there are another report at page 26 also. Submission of proposal. This is the proposal submission for the amount. Then
Where?
at page 26. First, I'll take to that. This is the submission for FOC proposal for the project. This was the proposal submitted by the divisional officer of the Nalbari Soil Conservation. And the amount here, your lordship will find at page 27. That 6.2, here lordship will find. Present demand 6.2. So it was there. Then your lordship will find at page 28, inspection report. This is the inspection done. The project site.
Anyway, those are issues so they have not disputed the fact that they have completed 80% of the work.
That they have
The
done.
only thing is that now they are now twisting that 80% to mean that that 80% is the actual work done, but 80% is actually 100% of the work done.
Actually 100%, but the maintenance part is this other part. So that I cannot do because it is already.
Where is the work order issued to you? Does that make it clear?
The work order is, your lordship will find page 16. Is nothing specific. has been-
Nothing is there.
Nothing is.
Let us see the NIT.
That is why. That is why your lordship I have annexed this, page 17 I have annexed.
Ah,
So this is where,
that page 19.
you know, here the page 19. So
But where
page
is the-
19
where is
shows
the-
two parts.
Where is the NIT? NIT will make it clear that
NIT,
how the
NIT,
work is to be divided.
yeah, they have actually given the general rules at page 57 of, in the running page 57, that is the affidavit. They've given the general rules and directions. Here also there is specifically nothing stated specific.
No, that's why I want to see the NIT.
Because-
No, is there something there?
NIT, your lordship will find, not the NIT, but the general rules and directions and guidance of contractors. That you find at page,
No. There was no tender issued.
the tender was issued, your lordship. And conditions of contract, everything is there
No.
from page
Where does
57.
it say?
Page 57, that is the affidavit, they have annexed.
Page 57.
This is annexure 2 in their affidavit, page 50.
No, you
running
see,
page-
they are saying that they have completed 80% of the work without mentioning the amount.
Yes. Not only thing, your lordship. 20%, 80% does not come. It comes about the whole amount
No,
of,
no, I can
Okay.
understand the other thing, but where's the
Problem is,
addition by them?
they themselves, because that is why I would like to point out that subsequently they have abandoned that project.
No, that's all right.
So
all
there is now no question of continuing that project. anymore.
No,
But
that's all
whatever
right.
I have done, I have to get back the.
I am not on that.
Oh, yes.
I'm not on that at all. I am on the issue of whether that 80% work completed by you
Yes.
pertains to that 6 lakhs. How do we connect that 6 lakhs?
That 6 lakhs, your lordship.
Yeah, that is only by your letter of 19. They
No,
might be
no,
talking
I
of,
have also, there is,
what I'm trying to say is that they might be saying that that 80% work you have done is of that 80%,
yes, that your lordship page.
not of the 100%.
Page 29,
Page 29.
yes. Page 29, completion report. Here it says, I've
Okay.
completed that. Here, your lordship will find completion report for sanction work, so and so, so and so, so and so.
And what have they said in the subsequent affidavit?
Here your lordship will find at page 30, they have given 80% progress of work completed. They have stated in that page 29 and 30.
No. What about the additional affidavit? What have they said there?
There they have issued an inquiry, there they have actually enclosed an inquiry report in 2023, after 4 years, where they said that this particular project was not completed. That your lordship will find. It starts from, I think,
I think best for you to go to a civil court. Or is there any, because they are dispute, I can understand your case.
no,
but
no,
whether-
they are not disputing. They are only saying the 80% you have completed. 100% you have not completed. The
But what are
completion report says 80%.
Additional affidavit, what have they said?
Additional affidavit is basically on the ground that your lordship will find at first, a page 115, one moment, page 115.
Yes.
This is the order of the sound report in this case.
Hmm.
Here, what is the order, your lordship? 10/2/2023. On the prayer of so and so, Learned Council Soil Conservation, is the case after tweak to enable instruction and not file affidavit in opposition. Then they filed this. This was on 6/3/2023. Next page, 6/3/2023. This was from the joint director to the director. Field inquiry report of that particular afforestation project. Here in the field report, their observations are given, whatever hectare and all. Now from there they found the conclusion part, the total area so and so, so and so, as measured in field, allowing extra 20% area due to so and so, so we are not concerned. Total number of RCC posts counted is 152. which is less than 247 number. The barbed wire is broken, can be measurable, so and so meters. Propose so and so number of varieties of appropriate plants targeted, but the field only 1,000 plants are noticed in so and so variety. Now the question is, your lordship, this is a peculiar thing. Plantation of 4 years, prior to 4 years, it has been planted, no maintenance done. You're expecting to get the trees grown. Even if I have a small garden, if your lordship keep the garden 4 years without doing anything, can one flower grow, your lordship? What kind of a enquiry
No,
report
but
has been
then
done after so many years?
no, barbed wire and then
Yes,
all these things and
are posted.
RCC posts.
yes.
You see, all these things now. have
No,
taken a
let
different
let us take a query. Why they have taken 4 years to verify, number one. And secondly, if the completion report has stated that I have done my work, this 80% work has been done, completed, everything has been correctly done, and it was certified by 2 officers. If that is false, this is true and that is false, what action has been taken against the officer for taking if giving false report? Let them come up and say, yes, they are giving a false report. Their own officers have given a false report, if that is a false report. Now, one thing, plantation, how that can be there? Even if I put, lordship, forget about anything, put some barbed wire here and go away for 4 years somewhere, come back. Whether those barbed wire will remain or not, I will just see it, your lordship. Nothing will remain here. Yeah, these are places in the, your lordship, riverine areas. I don't know how after 4 years, you make a, in what way they have gone for this enquiry? Your lordship? What about the earlier reports?
Tell me one thing, this page 29,
Yes,
what is the date?
page 29. Page 29 is a continuity, your lordship, up to page, I think, 33.
What is the date?
Date, it should be of, I think, 7th of December.
It should be the different thing.
No,
What is
because
the
from
date?
26 it starts. 26 is 7th of December. These are all enclosed in duplicate. So these are enclosed in duplicate in page 7th of December 2019. So it must have been done before 7th of December 2019.
If it
And
is
the
done-
checklist requisition
if it
from
is,
Form
I
C,
think- I
sealing
think-
approval, inspection report, then completion report. So everything has been annexed.
Yeah, at least date should be there.
Date, it is not my lookout whether they have given the date or
Yes,
not.
yes, what is the
See,
date?
lordship, two things. Here in the inspection report, for a moment, if you lords go there, they've inspected the site on 28/9/2019.
This is all photocopy anyway.
No,
Let me
they
ask.
have annexed it.
let
I have
me-
not
let-
annexed it.
No, this
It's
is
their
your,
document.
this is your petition.
My writ petition, but their document, not my document.
Correct.
Yes.
But yes, what is the, is this, do you deny the existence of this? Is it this page 26 to page 32, 33?
33.
33, my lord.
Yeah.
it-
That
it
is
was-
admitted document.
Yes, my lord.
Yeah.
But my lord, what is my submission, my lord? That the project, my lord, that has been, my lord, in my affidavit, my lord, that project was non-starter project, my lord. Because,
What do you mean not started?
because, my lord, I have stated, my lord, in my affidavit dated 3/1/2023, my lord,
That
page, my lord,
stated what?
my lord, as per my lord, that page 52, my lord.
Yes.
My lord, here, my lord, could not be started as planting season was over, and accordingly, as per the decision of the meeting dated 26 September 2019, these projects have been proposed to be closed, and as such, request was made to cancel the administrative approval of the schemes so as to reappropriate the proposal from protective afforestation to the head of land development. Moreover, the name of the petitioner appears in the list of non-starter afforestation plantation scheme during 2019-20.
Then what do you say with regard to these documents?
No, they have
But
stated,
regarding, my lord,
they've
80% work, my lord, we have completed, my lord.
They have completed 80% work.
80% of the work
They have completed.
completed.
Then you give them
And my
the,
lord, in the, my lord, that work order in itself, my lord, it was stated, my lord, there was no extension of time period, my lord.
all right,
no,
they-
I've
they
done it without-
completed 80%, you give them 80%.
And my lord, now the project has been closed, my lord.
So what? Did he complete his 80% within time?
My lord, as per these records, my lord. As
I've
per
done it
these
within
records,
45 days.
Just a minute.
Yes.
Come to page 19.
Yes, my lord.
Page 19, you see. Serial number 1 to 13.
Yes, my lord.
6 lakhs 11,000.
Yes, my lord.
And then the remaining is 86. Now he says that this 6 lakhs 11,000 is 80% of the work.
Yes, my lord.
So this he has completed. This is the actual contract. The whole contract is of course 100%, but that 100% will come into play only after he completes this 80%.
Yes,
So that 80% he has done. This 20% is only maintenance.
yes, my lord. But
Yes.
my lord, now, my lord, this project has been, my lord, closed, my lord.
But then he has spent money. You ask someone to cook you chicken tandoori and whatnot, butter masala, and then you say that I don't want it anymore. I think he spent money doing it. What to do then? You find money.
If your lordship goes in a restaurant, order food that I want have so and so, so and so, so and so, and the once food is prepared and got it to your table, and you say, no, I'm leaving, I don't want to eat. You are entitled to pay the. That is what has.
Okay, right. Heard Mr. NJ and heard Mr. Y.S. Manan, the counsel for the petitioners. And Miss
R.S. Deori, my lord,
R.S. Deori, learned counsel for
soil conservation.
all or what?
Not all, my lord,
For the soil conservation department. Who appears for the others?
all government advocate, my lord.
State is government employee.
Respondent number 3, government advocate.
Mr. Chetia, M. Chetia, or G. Bokalia, those. So for the DC,
Yes.
G. Bokalier appears for the respondent number 3.
But my submission may be recorded, my lord. That project has been closed, my lord.
Sure. Closed when?
My lord, as per later dated, my lord. Yeah, my lord, in my.
Immediately after my completion. It is there.
My lord, later dated 2nd February 2021.
So what does it say? From 2nd February, he was closed.
Yes, my lord, 2nd February, one letter has been sent by the undersecretary to the director.
Page.
Page, my lord, 102.
Due to non-starter of the project. That's what I don't understand.
Because in 1/9/2020, the director has already sent the proposal. No, the 101 page, there on affidavit, 101, your lordship will see. Now this amount is 620, which your lordship wanted to clarify, 620 has been given. The director at page 101 has stated in 19/2020, with reference to the.
No,
FD
he
on-
did 80% of the work. That you have admitted.
It is 80%, they have admitted that part only. I am not asking for 100%.
Whatever. The petitioners are aggrieved by non-payment of the outstanding bill amount of rupees 6,20,160. That's all. But earnest money, security money, how much have you deposited?
Deposit amount, your lordship, I think this amount is the total amount. The deposit amount is very less, not very high. It's very small. It's on.
For a person who has deposited, who was worried about money, you don't seem to be knowing how
No,
much you're
I-
supposed
I'm
to
not,
get.
not that, your lordship, because security, you have already deposited. Yes, security money, your lordship, has already been deposited. In the work order only it has been stated. But I don't know exact amount, your lordship. But that part, your lordship, otherwise also, I am entitled to it.
How much is it?
But that has not been given anywhere, your lordship.
That is, you see, it creates a suspicion as to whether everything is above board. When you don't even know the amount of earnest money, security deposit, you're asking for it and you don't know how much it is.
My lord, estimated cost is, my lord, 8.16 lakhs.
I know, but then he's asking
Yeah,
for earnest
estimated
money and security money
earnest
now.
money to put out.
How much is it? We don't know. How much earnest money and security money did he deposit?
Earnest money, my lord, 0.1632,
From where did he?
page 58, my lord.
Okay, yes. Security deposit, earnest money is 16,320 and security deposit is 77.
My lord.
No.
Original page 80, my lord.
It's 7,000. How can it be?
No,
Okay,
point, it is
77,500.
large. So it should be 16,320.
No, this is not. This is the general rules. How much you deposited, we do not know.
That
The general rules are for what? For the protective afforestation harm. Correct. What have I said? And a refund of earnest money and security deposit for executing the work, inverted commas, protective afforestation of Ahara village under SOPD-G during 2019-20 under the Nalbari Soil Conservation Division, which was allotted to the petitioners by work order dated 28/9/2019. You see, work order issued on 28/9/2019, but the project was closed 2 days prior by way of the meeting held by the minister.
no, here your lordship at
At
page,
page 102,
yes. No, that was the communication. your lord.
has already been cancelled as per the decision of the meeting held on 26/9/2019.
Yes, that is why your lordship will kindly see page 29,
29.
serial number 7. Serial number 7. Date of execution started on 29/8/2019, earlier, and completion on 26/9/2019. And here it is, yes,
But-
same day.
But your case is that work order was allotted to you on 28/9.
On my lord, 29/8, my lord, page
29/8, okay,
No,
your,
eight,
your,
it is eight.
your synopsis is wrong.
Sorry.
No.
It's eight, not 28/9.
That
It's
you
29.
see, we follow.
I'm
We-
very
we
sorry.
read everywhere.
Even I have I haven't seen that. So it was completed on the day of the cancellation.
Let us see the work order once again, page,
Page
page 16.
16.
On or before 26/9, okay.
Needs to be completed on. or
Was
before
issued a filed work order dated 29/8,
29/8.
2009. Yes, sir. The work order stated that the work was to be completed on or before 26/9/2019, or else the fund would lapse. Yes, sir. Next paragraph. The petitioner, this further case is that he completed the work. No, further case is that the work consisted of two parts. The first part being the afforestation of the doing the afforestation work, including the fixing of barbed wires, putting up RCC posts, providing and supplying tube wells, etc.,
Clearing jungle.
amounting to rupees 6,11,332. The second portion of the contract work was for maintaining the afforestation work done by the petitioner for 1 year. The petitioner's counsel submits that the afforestation work as required in the first part of the work, as required in the first part of the work contract, was with regard to the work to be done on or before 26/9/2019 and comprised 80% of the work. The remaining 20% of the work was for the second portion of the contract, which was maintaining the afforestation work done earlier
For 1 year.
for 1 year at a cost of rupees 8,16,114. Next part. The petitioner's counsel submits that the petitioner completed the afforestation work. Where is the completion certificate? Page
That is at page
29.
29.
Afforestation work on
Serial number.
26/9/2019. And thereafter raised his bill for completion of 80% of the work, amounting to rupees. No, don't say amounting, full stop. The same was verified by the range officer Rangia Soil Conservation Range and countersigned by the Divisional Officer, Nalbari Soil Conservation Division. And the and the bill value payable to the petitioner was stated to be 6.2016 lakhs, in terms of the completion report made by the above authorities. The petitioner's counsel submit that the said amount, that the above amount should be given to the petition. Next part. Miss
R.S. Deoli, madam.
R.S. Diori, the learned counsel for the respondents number 22. No, not 22. sir. For the soil
One.
conservation,
Yes, madam.
soil conservation department, submit that submits that the physical verification carried out by the range officer, Rangia Soil Conservation Range, Rangia, with respect to the work done by the petitioner showed that 80% of the work was to be completed by the petitioner, was completed by the petitioner. So, however, as per the tender agreement and work order, the petitioner should have completed 100% of the work by the cutoff date, that is 26/9/2019. He also submits that the project was closed as per the decision of the government
Yes, madam.
on 26/9/2019. And that the name of the petitioner appears in the list of non-starter afforestation planting, in the list of names who are non-starters for the afforestation plantation schemes held during 2019-2020. But that is a contradiction. On the one hand, you're saying that he has completed 80%. On the other hand, you're saying he's a non-starter.
No, they have actually cancelled the project as a non-start, all the projects.
Okay.
But in the meanwhile, we have already come. They have done it on 26 because she has not pointed out from the affidavit, your lordship, at page 95. Your lordship, this is the initial order. That was in 2019 itself, not 21. So on 15/10/2019, they have, in fact, the Director of Soil Conservation has issued the letter to the secretary.
So what have I said? No, that's it. No, next.
They have said that this amount has been saved due to the non-starting of it. And then again in page 100, they have.
No, just a minute. Page 52. You have again said at the second paragraph that soil conservation had asked for financial sanction and release of fund amounting to 6,20,160, which is claimed by the petitioner.
Yes, this is because your lordship will find they have annexed the document. This document is there at page 100.
He further submits that the Director of Soil Conservation, wide letter number BUD-8/Nalbari 2019/20/5961 dated 21/1/2020 had written a letter to the Secretary to the Government of Assam from a Soil Conservation Department praying to accord necessary financial sanction for an amount of 6.2016
And page 101 of same letter.
in
They have
respect
given-
of works done under the protective afforestation at Hahara village during 2019/20 implemented by the Nalbari Soil Conservation Division, Nalbari.
Implement. This is again-
Implemented
Yes, this is again
implemented by the Nalbari Soil during the financial year 2019.
to 101, same letter. They have issued in 19/2020, page 101. Same
So
letter.
don't say implemented, just say, because just say in respect of, because it's her submission,
Yes.
in respect of. Oh, no, it's here, again, implemented is here. At page 53, that the word is here. Good stuff. However, wide letter dated 2/2/2021 issued by the Under Secretary to the Government of Assam, Soil Conservation Department. The Director of Soil Conservation was informed that the protective afforestation at Hahara village under Nalbari SC division during 2019/20 had already been cancelled, as per the decision of the meeting held on 26/9/2019, chaired by the Honorable Minister Soil Conservation, etc. And as requested by DSC. What is DSC?
Divisional Soil Conservation.
As requested by the Divisional
Soil Conservation.
Division
Soil-
Soil Conservation?
Conservator, right? Not conservator.
Cannot be conservation. DSC means what? And don't forget that.
No,
And was made and was
Director of Soil Conservation.
and
Yeah, director only get director.
and was made and was and the project was named was and the due to the project being a non-starter. Being a non-starter. Not being due to the project being no due to the project being a non-starter. However, as allotment of work had been initiated against the above afforestation work, the Director of Soil Conservation was requested to thoroughly inquire to the matter and submit a report to the department for further action. Next. The next para, the Council for the Soil Conservation Department, by relying upon the affidavit, additional affidavit dated 30/06/2023, submitted by the Director Soil Conservation, further submits that a field inquiry was undertaken by the Soil Conservation Department with regard to the work done by the petitioner. Is it correct? Yes, Mr. Manan. Mr. Manan,
Lordship.
the inquiry report, the field inquiry was done with regard to your work,
With
correct?
regard to the
Regarding
Hahora.
project, my lord.
With regard to the work done by the petitioner with, and as per the inquiry report, it appeared that the petitioner had done some work, had done some work of afforestation as per the project, which was 80% which amounted to 80% of the actual work to be done. Yes, sir. That's all?
Yes.
Anything else, madam? I have heard the learned counsel for the parties. Yes, sir. The fact that the petitioner had done 80% of the work is not disputed by the state respondent. However, a perusal of the detailed estimate for protective afforestation at Hara Hara village which was to be done by the petitioner shows that the work has been divided into two components. The first component is in relation to the putting up of the barbed wire, construction of approach road, supply and fixing of tube wells, putting up of RCC posts. Besides, then planting of saplings, etc. The estimated cost being 611,332. The second component of the contract work, the second component of the afforestation work provides for maintaining the said afforested area for 1 year at the estimated cost of rupees 8,74
No, this is three
8,
nine one one.
16, sorry, an estimate cost of
This is,
39114.
no, 3911.
All total 8.60.
11,
11,
11,
70.
73, 42.
Yes. And
Next
GST is also added.
Huh?
They have also
Ah.
put GST. So it comes to 860.
And with the full stop. The above two estimated costs with the addition of GST at the rate of 12% comes to 8,16,000. Full stop. I think we'll stop for now because we'll take it up again at 2. At 2, huh? And if I don't do it,
My lord, that item number 18 and 19, I will like to withdraw and go for a arbitration.
better.
My lord,
Okay. Mr. BK Singh,
because
learned counsel for the petitioner, submits that he may be allowed to withdraw the writ petition and invoke the arbitration clause as there are disputed questions of fact involved.
as the contract has concluded, my
As the
That
contract,
may not- that
no,
may not be,
uh,
that may not be.
okay.
I will
Arbitration
inform the
clause,
Mr. Patel.
as the state respondents have taken a stand that the, and as they have taken a stand that the contract has concluded,
And there is a arbitration.
and there is an arbitration clause in case of disputes between the parties. Pusta. Mr. So, that KP Patha appears for so and so, and they submit that they don't have any objection to the prayer of the petitions council is allowed. The writ petition is dismissed as withdrawn, with liberty given to the respondents to invoke the arbitration clause.
Idea.
We'll continue at this. Pusta, the completion report with regard to the work done by the petitioner issued by the range officer, Rangdia Soil Conservation Range, and which has been countersigned by the respondent number 4, shows that 80% of the work has been completed. At a cost of rupees 6.2016 lakhs, which is a slight variation from the estimated cost of rupees. What is the estimated cost?
6,1.
No, no, that is not the estimated. 611,332.
1,000.
Full stop. That is. No, full stop. The completion report that clearly shows that the petitioner had completed 100% of the actual work to be done. Shows that 80% of the work have been done, and the maintenance component, which accounted for 20% of the work, was to be done for another year thereafter. The documents annexed to the affidavit in opposition filed by the respondent number 2 and 4 shows that the project had been closed. The project of afforestation had been closed in terms of the meeting dated 26/9/2019, on which date the petitioner had completed 80% of the work. The a reading of the letter dated 21/1/2020 and 1/9/2020 issued by the respondent number 2 shows that the Director Soil Conservation had asked for financial sanction and release of rupees 6.2016 for the work done by the petitioner. In this respect, letter number BUD-8/Nalbari/2020-21/1607 dated 1/9/2020 issued by the respondent number 2 is reproduced herein below. No, before herein produced, which shows that the afforestation work done by the petitioner has been implemented. Is reproduced below. Is reproduced herein below as follows. From page 101, from here to here. Okay. Next para. The additional affidavit filed by the respondent number 2 on 30/06/2023 shows that a field inquiry had been undertaken to verify the work done by the petitioner. And the conclusion of the field inquiry report, as given in the additional affidavit, shows that the petitioner had done the afforestation work, though had been done by the petitioner. First of, however, as the inquiry report had been made, three and a half years after completion of the afforestation work by the petitioner, the conclusion that the inquiry report shows that shows that the afforestation work shows that the a proper verification shows that only some works could still be seen. The conclusion of the field inquiry report as given in the additional affidavit is reproduced below as follows. Page 113 from now 1 to 4. Next paragraph. On considering all the above facts and keeping in view the completion report given by the respondents and the fact that the state respondents have not denied that the petitioner had completed 80% of the afforestation work as was required by him to do on or before 26/9/19, this court is of the view that the petitioner would have to be paid his due amount, his dues in terms of the completion report made by the state respondents, showing that the petitioner was entitled to the payment of rupees 6.2016 lakhs. As he had completed 80% of the work. Contract work, which in effect meant that he had completed 100% of the actual afforestation work. First up, only the maintenance work for 1 year was still required to be done, which accounted for 20% of the contract. In view of the, accordingly, the respondents, accordingly, the respondents are directed to make a proposal for sanction and payment of the required amount. Huh?
With the announcement. So I have not.
Amount, to be paid to the petition, full stop. The earnest money and security money, security deposit. Deposit, security deposit, the deposit, which has been submitted by the petitioner, if not returned earlier, should be also returned to the petition. The writ petitions accordingly disposed of. Accordingly allowed. Okay. After before that, you're right. The entire exercise should be concluded within a period of
3 months, ma'am.
3 months from the date of receipt of a certified copy result. The writ petitions accordingly allowed.
My lord, project is only for 45 days, ma'am. That-
So,
My lord, no, my lord,
45 days, I completed on the 44th.
if he completed on the day that the decision was taken to close the project,
But the communication was not there.
communication was much late. Communication was which date?
It was in 2020.
Acha, just right. The closure of the project was communicated to the was communicated
Here, page 95 text from the director of soil conservation, the secretary of.
page 95, huh?
Page,
Was communicated
it was 15/10/2000.
was communicated by the Director of Soil Conservation, Assam, to the Secretary to the Government of Assam Soil Conservation Department by letter dated 15/10/2019. You put that somewhere.
Time for respondent number 6.
I think this matter has become infructuous, I think.
Because we have not, petitioner has not participated in the this tender process also.
Okay, right. No one appears for the petitioner. Mr.
S. Kakoti.
S. Kakoti appears for
Respondent number 6.
respondent number 6, while Mr.
M.
Chettiar appears for the
1 to 5.
respondents number 1 to 5. Good stuff. The petitioner has made a challenge to the NIT dated 26/7/22, by which the fishery has been settled with the respondent number 6 by order dated 10/10/2022. First off, however, the petitioner has not participated in the tender process in pursuant to the NIT dated 26/7/22. As such, it appears that the petitioner has no locus standi to file the present case. Next paragraph. However, in view of the absence of the petitioner, this court, the writ petition is dismissed for non-prosecution. Correct.
24. So this petition has also probably become infructuous, my lord. The tender was for a period of 1 year, from 1/7/22 to 36/23.
This also is infructuous. Right, no one appears on behalf of the petitioner. The matter pertains to settlement of river block number 11. 11 number for the year 2022-23.
Page number 16.
Has no one, Mr.
R.B. Goswami.
R.B. Goswami appears for
3. Respondent number 3.
respondent number 3, while Miss P. Biswas appears for 1456. As no one appears for the petitioner. As no one appeared for the petitioner on the last date also. It appears that the petitioner are not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
25. Well, here my instructions are awaited. In the meantime, my lord, the petitioner may also have the instruction whether they want to pursue or not. My lord. His financial bid was rejected by office order, my lord. Therefore,
Because,
fresh tender has been initiated. No interim was granted. It was in 2022. Whether anything survives.
They still have to answer my. Only because I don't get my entry protection, but it's not that my.
It will be after 3 weeks in that case.
Let them file an affidavit.
I'll file my affidavit.
No, you tell me your case.
But the minors I have already placed. It's there in the.
What is your case?
My case is blood, they have illegally rejected my blood.
Why? What is the illegality?
But they say that my blood, my bid is very low blood, and I have submitted justification for that.
Then
That is my case.
your bid was 30.59% lower
Yes.
than the estimated amount.
Because I
So
did
is it a requirement that they have to accept your justification?
that is the requirement, your lordship would adjudicate, my lord.
No. Have they, so they have rejected.
Yes.
So what is wrong?
But that
Yeah, what is wrong? They are the best authors of that tender document, of the terms of the tender. Let us see the NIT.
not challenging the terms of the tender, man.
Let us see the NIT. If you're not challenging, let us see the terms of the tender. What does it say?
Page 44. Relevant will be clause number 28.
Page 44.
Yes. Evaluation and comparison of financial bid. Clause, my lord, 8 under 28.6, it has been rejected.
What is wrong?
They must, my lord.
No, you have to, you see, this is a contract tender matter. Now, you have to inform this court. Has this, how many valid bidders were there? How many valid bidders were there?
So you will find at page 123.
123, my lord.
How many?
6.
6 valid bidders
Yes.
after disqualification of the petitioner.
After disqualification, my lord, in the financial bid, his bid was not accepted. Otherwise, my lord.
How many financial bid? How many open?
6.
6 financial bids
Yes.
open. So he did not reach that stage. His technical bid stage, he
Technically, he
He
was
succeeded
qualified.
technical, But in the value, in the financial
Financial
bid,
bids were found to be too low.
correct. Now, is it your case that this has been done to favor somebody?
In my case, that I could quote that price and it was sustainable for me because my procurement was such that I could provide them.
But that is no ground. That is no ground.
Respond to it because I have made.
Mr. Council, first you respond to me.
Fine.
Then I'll think of whether what I should do. Let me think, not you. Yes, so I'm asking, when I ask a question, please answer it. Don't tell me what I should ask them. So the question is, first of all, is it your case that you have been disqualified or not accepted, your bid has not been accepted to favor somebody else, to favor some particular person?
My case,
No, just say, answer that, yes or no. No,
my case, the decision which they have made, my lord,
yes.
which is arbitrary, my lord.
Where is the decision?
Page 124. Yes, they have asked me the justification. We will see the office memorandum of page 125.
Your justification is page?
My justification is page 128.
And where is the rejection of your justification?
140, 142. my lord. We will see the-
Wait. 128 is your justification?
Yes,
This three line page.
along with the documents I have annexed, my lord.
And it is from 128 to 130? Or
Yes.
what?
We have given the text in tailwind voice regarding the rate I am procuring, my lord. Why am not the, why my rate is low? Because I am getting this, which I have indicated to the authorities, my lord. This is my justification for putting a lower rate, my lord, because I am getting at a low rate, my lord. I am purchasing in bulk, my lord. You lordship would see their rejection. At 142. So there has been instances that which we later came to know, they have also accepted lower roads in other contracts also.
Mr. Go, is there any explanation besides this?
My lord, we have placed in a, my lord, it's in the court's record. There, yes.
Hold on.
See, my lord, there are 4 grounds, my lord, they verified their invoices.
Yes.
One, may I point out, my lord, in the original estimate, 250 kVA, so and so, copper wound transformer was considered, whereas the bidder has submitted text invoice of aluminum wound transformer. Second, my lord, required brand of UZ cable is to be Havells or RR cable or Polycab, whereas the bidder has submitted text invoice of KEI. Regarding DG set, the bidder has submitted only the company quotation. No text invoice has been submitted. So yes, he doesn't have the DG set. Failed to provide storage of stadium mast as per BOQ. Bidder has mentioned that there is a godown at Boragaon, whereas the materials are shipped to different places of Assam as per text invoices. So after due verification, my lord, the committee who is the expert, they have taken the decision.
He not entitled to what is placing for your lordship. I have a right to reply. That's why they are not filing an affidavit. But in the being on record, this stand, because your lordship is page 142, how will I can respond to their decision, my lord?
This is the records are there with you.
My lord, at least I should be given a copy so that I can respond to it. Otherwise, my lord, it's only one-sided, my lord, affair, my lord. But at least I have a right to reply, and I have a right to know, my lord, what is the reason. It's not that they will place before your lordship without the petitioner being knowing it, my lord.
Give him a copy,
If they file
photocopy.
an affidavit, I'll respond to it.
You give a photocopy.
I will provide.
Give a photocopy, that's all.
You have a right to respond to this, my lord.
You respond, you've been given.
Lord, it is not my case individually, my lord. I have to take instructions on this, my lord.
Huh?
I'll have to take
No,
instructions.
no, I'll give you day. I'm not disposing it. I'm not disposing. I'm not disposing. You go and talk to your client if you want,
Definitely, I'll have instructions.
but no affidavit. This is enough.
On basis of this, I'll make my.
That's all.
If so required. Because this is the decision-making process, what they are saying, so I can respond upon.
You respond.
Yes.
Heard
Give
Mr.
me 2 weeks time, my lord.
Heard Mr. R. Dubey, learned counsel for the petitioner. And Mr. B. Grover, learned counsel for this. All the respondents,
Yes, sir.
Yes, my lord. All right.
counsel for all the respondents. Oh, it's already here in the order.
It's already there, my lord.
It's already here, Mr. Counsel. You already know about it also.
They have placed before your lordship on that day.
It's already listed in the order. The entire that 1 to 5 is here in the order itself. What do you mean?
My lord, the copy was not.
This is of 13, 12, 22.
My lord, will kindly see the
No, no,
press
no,
release
no.
and all, my lord.
I've heard enough.
But they have not filed affidavit, my lord, also.
Heard.
Not that on basis, on the otherwise
Heard.
that day only, my lord, your lordship.
Mr. R. Dubey, learned counsel for the petitioner. And Mr. B. Grover, learned counsel for the state respondent. The petitioner. Has the contract been awarded to somebody?
That instruction today, actually, is a holiday today, madam.
Huh?
Today is a officially.
This order is of 22.
I understand, madam. Probably, but that's why I said, well, probably it is already over. In fact, the works will be over. Electrical works, you don't take.
No, he doesn't have a prima facie, he doesn't appear to have a case. Only problem is, you just get the facts, you call, after 5 minutes, you take it up. Just ask them what has happened to this.
My lord, I can have it.
Take it up after 5 minutes. Depending upon that, we'll see.
I have to take it tomorrow. So that in meanwhile, but I have no increment.
Mr. Counsel, this order regarding that document that you have in your hand has been reflected in the order of this court in 2022.
That means that my case should have been dismissed on that very day. Why notice was issued so that they can.
You see, that was the very ground that the interim order was not passed. Next.
File an affidavit, I could have responded.
On the last occasion, my learned friend had used an instruction to show that the work which was allotted to the contractor, the award which was given, has finally come to an end. Basically, we had made a challenge to a decision for rejecting my technical bid, in the repetition that is 5271, which has given a reason for rejecting my technical bid. And the reason was that the technical bid.
So they are instructors.
Yes, Lord. Supply order has
Already been done.
issued, Lordship. It's already,
Okay, right.
this is my instruction, Lordship.
No, since both of you all have agreed
I have copied instructions, I'm going to send the record on instruction point 9.
that the materials have been supplied.
Materials have been And bills have also been
Paid.
Supply order already have been issued to the L1 bidder lordship.
L1 bidder and
As well as a
payment
agro
made.
Services and
On the process that what I have done.
Okay, anyway, so supply be made. Okay, right. Heard Mr. H. Buragohain, learned counsel for the petition in both the writ petition, and Miss
Arbora lordship.
R. Bora,
Standing council.
Standing
Agriculture
Council, Agriculture Department.
Lordship.
Full stop. The council for the parties submit that the writ petition has become infructuous in as much as the supply of Napier slips has been completed by the L1 bidder.
L1 bidder.
And the process for payment for the supply of materials is under process. Full stop. Next para. In here, the submission made by the council for the parties, the writ petition is closed as infructuous.
Obliged lordship.
Writ petitions are closed as infructuous.
No file was that notification.
But you have complied with the order.
Notification there.
See that matter, they are not following my regular settlement, they are giving that at daily basis.
That was already.
In the meantime, my lord, on the last day, Lordship, can you have a look at the last one? They have.
Yes.
Notification.
It is in the.
Okay,
in
so
the
I
file.
mean, so so it's very infructuous in a way, because as on, because it says that from which date?
Before 10/5/24.
From 10/5/2024.
Nothing was there.
10/5/24 will be the last date
Last date.
For them.
for the daily basis,
Last.
My only prayer, my lord,
for the in the IA.
Last.
I am my lord is there, my lord.
Yes,
My
okay,
name
right.
is
Regarding- Regarding subscription
my-
part, we have no objection.
They cannot.
We have no
My
objection.
name.
We have no objection.
Only my prayer is that, my lord, the order which they have given in the court, my lord, that has to be implemented.
Has to
That
be,
has to be followed, my. Otherwise, what they
This
will
is,
do, my.
this is done
on
as per,
11th, my lord, they will come, they will give to another one.
this
Again,
is,
after approval, your lordship.
this is done as per my lord's order.
a new set of fees for you.
Lordship.
I don't want, I don't want
This
that.
this is done as per my lord's order. That by particular
In respect
notification.
of
I should-
another case, my lord, the
Lordship.
order has been produced before your lordship, my lord. That has to be implemented in true terms.
Lordship.
They have to follow the rule.
Okay, right. Heard Mr. Jay Burbuya, learned counsel for the applicant who submits that
We don't ask for this here.
due to the death of the secretary of the petitioner number 1, the new secretary of the
Society.
society, that is, the new secretary of the society should be allowed. Mr. K. Gogoi, learned counsel for the respondents,
Respondents, Lordship. Respondent 1 to 5, Lordship.
1 to 5, and Miss
As there.
S. Dev. Learned counsel for the respondent number 6, submit that they've got no objection to the application being allowed. Full stop. Accordingly, who is the secretary?
Now, my
The new
lord,
one? The new one to be pleaded?
that is, my lord.
Accordingly, the new secretary,
Ticket number.
Vijay Malla, Lordship.
the new applicant, Shri
Vijay Malla.
Bijay Malla, MALLAH, BIJAY, is allowed, is pleaded and allowed to substitute the earlier secretary of the writ petitioner number 2. That is the writ petitioner number 2. Shri Anil Das.
Late on.
Late Anil Das. Applicant shall give us corrected copy of the cost title to the registry. I is accordingly allowed and disposed of. Then next, in the next case, you write, in view of the order dated 1/5/2024, passed in IAC 1259 of 2024, Shri Vijay Mala, so is imputed and allowed to substitute the expired secretary of the committee of the society. That is the respondent number, petition number 2. Then you write. Acha, before that you write, heard Mr. Jai Burbuya, counsel for the petitioners. Full stop. Mr. K. Gogoi appears for the 1 to 5, while Miss S. Dev appears for point number 6. Next para. Then the last order, page para 3. Para 3 you write. Then next para you write. The order dated 12/4/24 issued by the Commissioner Secretary to the Government of Assam Fishery Department is reproduced herein below as follows. From perused till 13/5/2024. Okay. Next, in view of the above order dated 12/4/2024, the present date petition has become infructuous, as nothing is left to be adjudicated any further.
In case of their failure, I may be permitted to. In case of their failure to implement.
They have already done this.
It's always open, Lordship.
I have to follow the truth.
It's like saying, in case Mr. Jai Barbuya does some illegal act, he should be caught and taken to court. We don't know what will happen. It's clear.
Has to be implemented in true terms and spirit.
That's what they're going to do. They said that the regular it will be done.
Petition stands closed, man. Instead of little what.
I said closed as infructuous. There you go.
What is during the pendency of this conduct petition of the 2 years back, of the paid a part payment of rupees 20 lakh. Another 13 lakh is yet to be.
1-3.
1.
Perhaps my friend has to increase the new income rate. It is to 2020.
Okay.
Already there.
So you implement the new incumbent, Mr. S.K. Das submits that during the pendency of this contempt case, rupees 20 lakhs has been paid. Leaving approximately rupees 20 lakhs has been paid, leaving a balance of approximately rupees 13 lakhs. He also submits that he will file an application for impleting the new incumbents. List the matter after 2 weeks.
All right.
3 weeks. 3 weeks.
But here, my instruction is that they have already moved the finance department. It is with the finance department. They after financial sanction, it will be paid. They have already moved.
It's a small. How much left?
93,190.
Not very less.
Small amount is left.
Okay, right. Mr. Deenat submits the finance department has been moved to pay the petitioner the remaining balance amount of rupees 93, 93, 191. 192. List the matter
But
after 3 weeks.
after 3.
The last 4 opinions, to 10 to 5 like it.
Who is this?
To agree, I can say which.
Mr. B. Chaudhary is absent today. Is he in some other court?
The content is pending since 2022.
How much is to be paid?
2022.
What is to be done?
I think it is.
Around 9,22,000 has to be paid.
Please, Your Lordship. Lordship, Mr. B. Chaudhary is, appears for this matter. He's on legs in court, 7, but he's instructed me that the instructions are still awaited regarding the.
Then we'll ask them to appear as before. You see, the one order I've got here in front of me is of 7 September 2022,
Lordship, this is
asking for time to file affidavit. Now more than 1.5 years have gone by.
Your Lordship, there's some updated instruction here regarding the verification whether the petitioner is entitled the.
Lordship here, as in the another contempt lordship on Monday, we have shown it, lordship, the audit was done and list of PWD has been prepared.
List of?
List of the audited schemes, which shows that they were genuinely, the work has been done because the liability exceeded the budget. So, lordship here, the list has been prepared. Whether the petitioner's name is there or not, lordship, that has to be verified. Lordship may take it up next week, lordship. I will have it. I had a talk telephonically since today it is a holiday in office closed, lordship. Lordship may take it up after a week.
You see, on September 2022, you had asked for time.
Yes, lordship. The list has been recently up to date and prepared. Final list is out. Lordship,
List prepared by whom?
by the BTC authorities. Of each department, lordship, PWD has also been prepared. On Monday, lordship, I have shown PNRD department.
His work relates to which department?
PWD.
Okay, you'll bring it next week.
Yes, lordship, after any date, lord.
Mr. B. Chaudhary, learned counsel for the BTC submits that the list of persons who are to receive outstanding dues
in terms of Tamsir Ali.
in terms of Tamsher Ali and others versus Union of India and others, 2008, 8 GLT, state of Assam, 2008, 8 GLT, what? 1. 2008, 4 GLT, 1. To be prepared by the PWD. He shall produce the same on the next date. List the matter on 10th.
Lordship, can it be on 13th? Okay.
13.
31.
It's clear that they have not complied.
Is it a part of the report?
No, my lord, that affidavit, the respondent number 1 has filed it yesterday. And my lord, one review petition was also filed, my lord, against that order, my lord.
Where is that order?
No, my lord, the order passed by the report, non-compliance of which has been complained hearing. That is order dated 4/8/2021, passed in WPC 2789 of 2019. Now the state, my lord, has filed a review petition. That review petition was listed today before Honorable Court number 23, Justice Ete, and my lord, notices has been issued. And till the returnable date, returnable by 4 weeks, the operation of this order has been suspended.
Okay.
And the fact that, my lord,
Then what is the review petition number?
that is 64 of 2024. Review petition number 64 of 2024.
It was fine, but
Huh?
there has to be a confirmation.
Mr. Counsel, whatever it is, that review is not before me. Then I've got nothing to say. Okay, right. Mr. R. Chakrabarti appears for the petitioner. So, Mr. R. Pujari appearing for the respondent number
One, my lord.
one submits that the order dated 4/8/21 passed in WPC 2789 of 2019
My lord,
has been
suspended.
While order dated 1/5/2024 passed in review petition number 64 of 2024.
2024.
Accordingly, list this matter after
4 weeks, because there, my lord, notice has been issued returnable
After
by
4
4
weeks.
weeks. Lordship may also kindly indicate, my lord, that the respondent number 1 has also filed an affidavit, although this is not on record. Yesterday, we have filed it. In the contempt
okay,
petition.
right. Mr. R. Pujari also submits that the respondent number one has filed an affidavit, though the same is not on record. Registry to place the same on record.
I'm so obliged.
4 weeks. 4 weeks. Huh? Huh? Infractions. Oh, okay. Yes.
Right.
Others been complied with. Mr.
Alim Sheikh.
ARD
Alim Sheikh.
A. Alim Sheikh, appearing on behalf of Mr. M.U. Mandal, learned counsel for the petitioner, submits that as the order dated 19/10/2022 passed in WPC 6578 of 2022 has been complied with. The contempt petition can be closed. Accordingly, the contempt petition stands closed.
Since as per my instructions, the order has been complied with. What my landed can say. They may obtain instruction from their client.
Do you have your phone number of your client? Is it your senior? What you do is you call your senior now over phone. Ask him to contact the client and who should state whether the order has been complied with. And then you just inform. There's no point keeping this pending. It goes up and down, you know. We have got so many matters here. Okay, just ask, okay? Just now. Come after 10 minutes.
34. Petitioner has informed me that we are pending this.
Okay. Mr. J. Deka, learned counsel for the petitioner, submits that the outstanding payments to be made by the respondents have been done. Accordingly, the contempt petition can be closed. In view of the submission made by Mr. J. Deka, the contempt petition stands closed.
35.
Dated 29/4/2020. Foundation.
Next steps are what to do. What do you think should be done? I think that's the best because the last one was last year. Or can you take Dasi service? No. Okay, right. Office note dated 29/4/2024 states that there is no return of AD card or unserved notice from the respondents number 1 and 2. Petitioner to take fresh steps for service of notice upon the respondent number 1. Within 3 days, list the matter after 4 weeks.
Item 36.
Well, I prefer further for each time, but I have not received the instruction.
So 7 and 8 is complete as per Lawazima portal. Mr. D. Nath, appearing for the respondent numbers
For 1 to 6 months.
1 to 6.
1 to 6.
Submits that instructions are awaited. Accordingly, list this matter after 3 weeks. Before that, just right, as per the office, as per the Lavazima court order dated 24/4/24. Service is complete in respect of respondents number 7 and 8. This matter after 3 weeks.
Lordship, we have received our instruction, we'll file our affidavits.
What is the instruction?
Lordship,
Admitted.
no, Lordship, there are certain factual,
Discrepancy.
yes, Lordship.
Anyway, let it fight. Mr.
U Sharma.
U Sharma,
Correspondent, the sole respondent.
or the sole respondent submits that instructions have been received and he will be filing his affidavit within
4 weeks. Lordship.
right? Within 3 weeks.
Yes, sir.
Within 3 weeks. Please the matter after 3 weeks.
Highly obliged.
Other side is informed, they file an affidavit.
Which one? Item? There was a prayer made from your side that you wanted to go to Lok Adalat or something.
That is there, because it was last listed on 25/4.
Do the government want to go to the Lok Adalat? I don't know. No, that, it has to be it has to be two-way traffic.
Instead of 22nd April, as item number 55, next date is 11/5.
What is this 8-3? What is this? What is this you're giving me?
Lordship, there was a like
Oh, wait, this IA is for striking off.
striking.
Yes.
Who?
Respondent number 8.
Any objection?
Because at
Huh?
that point of time, he was in the office. Now he is not. At that time, he
I
was.
already resigned before receiving notice. And I was a fourth grade. The wrong designation is given there in the first time.
You're a fourth grade.
I'm fourth grade. I'm just a
But
translator.
operates computer.
No, I'm a translator, not operator.
I don't know.
I'm a good.
What? Huh?
The lady.
Right. Mr.
My name is Kenan.
A. Nazari, learned counsel for the applicant, praised that the respondent number 8, Shri Ripun Boro, should be struck off as a party from the case, inasmuch as the applicant was working as a translator in Bodo language at the Assam Sarba Shiksha Abhiyan Mission Kaliapara, Guwahati, at the relevant point of time, and had nothing to do, and has nothing to do with the issue at hand. Ms. B. Gogoi, B. Bhuyan, the learned senior counsel, appearing for the writ petitioner, submits that she has got no objection to the prayer made by the applicant's counsel. In view of the consent of the parties, the respondent number 8, Shri Ripun Boro, is struck off as a party from the case. Huh? Then in the main case, you write, in view of the order, in the disposal, huh? In view of the order dated 1/5/2024, passed in IA C 837 to 2024, the respondent number 8, Shri Ripun Boro, is struck off as a party from the case. Huh? Yes, the main case.
He filed the affidavit, Mr. B. Yesterday he was informed us.
Tell me one thing, madam. There was no NIT.
There was no NIT.
There was no
But
work order.
Practice prevalent in that office. I have delivered the substance, what if material, they have received it, you believe I not?
And they've kept it.
Under section 70 of the contract act, even if there is oral agreement between the parties, my lord, they are responsible to make it.
Can government make oral agreement?
That thing, regardless.
They-
They will
they-
find an affidavit since the notice.
Okay, what?
My lord, we have received a communication letter from the executive director SSA, my lord. Here it is stated that no work order was issued in favor of the petition. My lord.
Instruction which you have received before we move, that's why I could observe that you filed a short affidavit. You were not there, you were not properly instructed.
Are you going to counter the petitioner's counsel or not?
With my senior counter, I have my.
This is literally informed me yesterday, my lord, they're going to file an affidavit.
Okay. Out here, that B. Chaudhary has paid for time, right? Okay, right. Who are the council for the respondent numbers 2, 3, and 4, I think. Madam, you're there also? And are you filing any affidavit? No. Okay, the respondent number 2, 3, and 4 shall file their affidavit within 2 weeks,
3 weeks, my lord.
within 3 weeks. So, Miss B. Deka appearing for respondent number 1 submits that the respondent number 1 will not be filing any affidavit.
No, Lordship, actually, Sarva Siksa is the main party. We are the formal.
So you're filing or not? Then that's what I said. You're not filing. You have got to take a stand, madam. Either this way or that way. Can't be in the middle.
Formal party.
List the matter of the 3 weeks.
Obliged, my lord.
IA 566, my lord.
This for what?
In my lord, for correction of some my lord typographical mistake, there are 2, my lord.
Ah.
The respondent number is inadvertently and mistakenly typed as the state of Assam, represented by the commissioner and secretary to the government of Assam, instead of the state of Assam, represented by the commissioner and secretary to the government of Assam, Public Works Department, Assam district.
Okay. Okay. So, respondent number 1.
1,
Okay, right. Heard, Mr.
M. Sarkar.
M. Sarkar, learned counsel for the applicant. Read petitioner. / read petitioner. Who prays for
And my lord, further, my lord,
for deleting the name of the respondent number 7 from the array of parties.
Yes.
And correcting the cause title in respect of respondent number 1 by replacing the state of Assam, represented by the commissioner secretary to the government of Assam, by the state of Assam, represented by the commissioner secretary to the government of Assam, Public Works Department, Assam, Dispur, Guwahati 6. Full stop. Any objection?
No, madam.
And
The other,
huh?
other my lord respondent will be my lord, 2, 3, 4, instead of my lord, 2 will go on my lord, because my lord, that mistake is there, my lord.
Huh?
Respondent number 1 and 2 should have been 1 respondent.
Yes.
They will split it. State of Assam, given by Public Works Department. The lordship is goes.
Oh,
Main
okay,
case,
okay.
then it will be number.
Okay, full stop. Full stop. Accordingly. No, before that, right. Mr. S. Bora, learned counsel for the
BTC lordship.
for the BTC and Mr. B. Gogoi for the
PWD.
PWD. You're there also? Stuck off. So you're gone. Okay, no need. Mr. B. Gogoi submit that they have no objection to the application being allowed. Full stop. Next, in view of the consent of the parties, the respondent number 7 is struck off as a party from the case. Full stop. The cause title is to be corrected by making the respondent number 1 as follows. The state of Assam, represented by the commissioner secretary to the government of Assam, Public Works Department, Assam, Dispur, Guwahati 6. The respondents number 3, 4, 5, 6, and 8 shall thereafter be the respondents number 2, 3, 4, 5, 6. Huh?
8 also there. 8 will be 7.
No, 8 will be 6.
Oh, 8 is 6.
The IA is accordingly allowed and disposed of.
For this, my name is appearing for this.
I registered to strike off the name of Mr.
Yes.
SCKL SCGST. The SCGST from the cost title. His name is not required. And in the main case, in view of the order dated, 1/5/22/24 passed in IAC number 566/2024. The respondent number 7 is struck off as a party from the case. The respondent number 1 shall be known as State of Assam, represented by the Commissioner and Secretary to the Government of Assam, PWD, huh? Thereafter, the respondents number 3, 4, 5, 6, and 8 shall be recorded as 2, 3, 4, 5, and 6. Shall be renumbered as.
Your CIS, CIS, you have to give a phrase cost title. Then they will be
corrected.
corrected.
First stop. In the main application also you write, the applicant shall accordingly give a corrected cost title to the registry within 2 days. Huh? In the main case, you write, list the matter after. Anything to be done? Affidavit?
No, affidavit, let it come after 3
Okay.
weeks.
In the main case, you write the respondents are given 3 weeks time to file affidavit in opposition. This is the matter after 3 weeks.
Lordship, we have received the instruction, Lordship.
Yes,
Lordship, we have received the instruction, Lordship.
show it to him.
Pending on.
It's pending. So this application can be closed,
With directions to them to.
dispose of.
My matter within 45 days, which is the time period.
In terms of? In terms of?
In terms of.
Right. Heard, Mr.
Dida.
Didas, learned counsel for the applicant. And Mr.
N. Kalita,
N. Kalita,
on behalf of A. Kalita.
on behalf of Mr. A. Kalita, counsel for the respondent. Mr.
It does not say whether the council is operational or not.
Lordship, it is functioning, Lordship.
Functioning.
Yes, Lordship.
So Mr. N. Kalita submits that the Felicitation Council is in existence and is functioning at the moment. He further submits that the petitioner's application dated 8/8/2023 regarding non-payment of bills is pending before the Felicitation Council. Is it correct?
Lordship, after the mode of conduct, after it gets over, Lordship, they'll be sitting with them, Lordship.
How does it bar it? I don't know, but anyway, that's a different issue. 45 days from now, that means it'll be up till 16 June. So more elections, probably the results will be announced by 2nd, 4th. No, MCC might be till 6, but that announcement can be prior to that. So anyway, you have got enough time. Okay. Right. This is Air Transport Private Limited.
Corporate.
Air Transport?
Corporate.
No. It says Air Transport Private Limited status.
Corporation Assam Private.
No, out here in this letter.
I think that may be.
Just give him another copy, Mr. Counsel.
No, there should be no.
You don't have any other copy? My God, why?
Lordship, I have.
Okay.
Well, that is not my.
Huh?
That is not the entity, Air Transport Private Limited. It is Air Transport Corporation Assam Private Limited.
Then? Where? That's what, this is air transport. You said that it is,
Air Transport Corporation Private Limited. So they missed out the words corporation and Assam.
you have got no other cases with them, no? So it must be this one only.
I
This one.
think that.
Full stop. Full stop. In view of the above, comma. No, in view of the above, in view of the fact that the Felicitation Council is is functioning, and as the petitioner's application is pending before the Felicitation Council, the council is expected to take a decision on the petitioner's application within a period of 45 days in terms of, please confirm. It's not there.
Well, it's there. Or you want to make it as per the MSME Act? Whatever the rules are. Or maybe give it some time.
Show me the act. Okay, we'll fill that up. Let him look. He'll just give it to me later. Give me that. Or I'll change it as expeditiously as possible or whatever. Okay.
Like, I think.
And the applications accordingly disposed of.
Like.
Timing 25.
Well, the tender process has been completed, work allotted, and it is a verge of completion as per the first tender.
Given to whom?
But today office is closed, madam. The chief engineer is informed, madam. That office that.
Then we'll have to
Okay,
challenge
okay.
that. Now this petition has become infructuous.
As per the action.
If the work has been allotted to someone on the verge of completion, then what remains?
There.
No, but then you see, even if the decision making, supposing we have to hold, the decision making process is wrong. What can happen?
Opposition was
Nothing.
given
All
to
is
him
up to.
After considering his reply decision.
I know.
There's the arbitrariness.
The only thing to see, we have got to see whether the procedure was followed. That's all. There's nothing now. There's nothing. Can you give me the name to whom it was given?
The work order is with them, my lord. They've done it.
Then I can, my lordship is already, my lord, lordship keep it.
Tomorrow?
Ordered, my lord, yes, tomorrow or
Tomorrow.
on Friday, my lord.
Tomorrow?
Tomorrow,
Tomorrow.
my lord.
Okay.
Can it be Friday?
Friday, okay, right.
Friday.
Yeah. Heard Mr. R. Dubey, then counsel for the petitioner, and Mr. Big over, the counsel for the PWD. System. The petitioner being aggrieved by not being awarded the contract had. Where is the earlier writ petition?
No, there is a.
140. We were asking for direction checking the decision with page 142.
The second tender notice is a page my lord, 143. I will have instruction on that for you. The president.
This one.
42 is the decision and 140 is the consequences. Taking my bid, so they are going.
Has filed the present writ petition. This court, wide order dated. The case of the petitioner is that the petitioner had submitted his bid at this item number
25.
at 30.59% lower than the estimated amount. So sorry. The petitioner was asked to justify his low tender bid amount. The petitioner subsequently submitted justification for submitting his low bid amount. The same was scrutinized by the tender committee and was rejected on 5 counts. The same has 5 counts wide letter dated 23/11/22. No, what was it? 5 counts, which was communicated by letter dated 23/11/22 issued by the additional CE PWD bracket electric bracket close SR. The meeting minutes of the tender scrutiny committee held on 18/11/22, rejecting the petitioner's justification for his low bid amount, has also been made a part of the order of this court dated 13/12/2022. Next para. There is no stay order, no interim order passed by this court with regard to the contract work in question. There's no interim order passed in pursuit to the subsequent tender notice. The subsequent NIT dated 2/12/22. Did you participate there? In which the petitioner did not participate. Next para. Mr. B. Gogoi submits that pursuant to the NIT dated 2/12/2022, tenderer has been selected who is on the verge of completion of the contract work. He submits that he will provide the details within 2 days. So accordingly, release this matter on Friday. 3rd.
1933.
Yes, madam. That's what. You see, now less work for them, for the registry. Miss M. Bharati appearing for Your Vakalat number is not there. Who's your senior? Appearing on behalf of Miss M. Bhattacharjee, Learned Counsel for the petitioner, submits that the order dated 7/9/22 passed in WPC 5458/22 has been complied with. So, in view of the submission made by the counsel for the petitioner, the contempt petition stands closed. Yes,
Your Honor, the
okay.
period would be 90 days, not.
Okay, within 90 days, huh? 90 days under subsection under section 18 bracket 5 of the MSME Act 2006. Okay. So today is Wednesday.